My Lords, we begin with the statute dealing with section 36 of the Competition Act, set out by the Tribunal in paragraph 175 of the judgment. So core tab 16, page 370, please. I'm on my first penalty issue relating to the concept of undertaking. My Lords, if one looks at subsections 1 to 3, the common theme is that Parliament has expressly addressed each of those sections to the undertaking. That in relation to Chapter 1, Chapter 2 infringements, it is the undertaking that may be required to pay a penalty, and in subsection 3, the CMA may impose a penalty, as was described by the appellants. This is a jurisdictional requirement. If the CMA is satisfied, the infringement has been committed intentionally or negligently by the undertaking. And immediately under the statute, in my submission, the Tribunal rightly says in 176 that, of course, exposure to a penalty is again by reference to the undertaking, which it underlines. And it goes on to make the point that intention and negligence is again by the undertaking. And for your note, the CMA says the same thing in paragraph 10.22 of the decision on page 1621. Now, the submission was made on behalf of Allergan on day 2, page 100, that intention must be established at the level of a parent company. That is incorrect. Parliament has made a deliberate legislative choice to use the expression undertaking in preference to a company or legal entity or individual. Indeed, this court in Safeway and Twigger, the authorities, tab 23, page 692, there's no need to turn it up, but it's paragraphs 23, 36 and 43, this court said in terms that the liability to pay the penalty is personal to the undertaking and no one else, in that case being concerned with trying to recover it from the directors. Now, if we can go down the page, please, in the judgment. I apologise. My Lord, yes, you were the judge at first instance in that case. Yes, my Lord.
So from me. I can't remember what the result was. I remember the case.
So the result was that the companies couldn't recover. My Lord?
1-0, wasn't it?
Yes, my Lord. That's the pithy way to summarise the outcome. But an important point of principle.
Yeah.
The Tribunal at 177 draws the threads together, and it's worth just sort of casting an eye over that. So we see in one, state of minds can be relevant, specifically to penalty. But in two, the Tribunal reiterates that the entity, and it's really 4 lines down, whose state of mind must be ascertained is that of the undertaking, which is the Tribunal described as an economic unit. And then 1773, the Tribunal points out that, of course, employees, contractors, corporations, I might add subsidiaries, they're individuals, they are all form part of the same, they may form part of the same undertaking. And this court, as my Lord Justice Green pointed out, made a similar point about undertaking in the judgment in VW and CMA. I'll just give you the references for that. Paragraphs 84 to 88, authorities, tab 54, pages 1606 to 1608. But if we go over the page, please, to subparagraph 4, the Tribunal then says what is clear is the knowledge and states of minds of all actors part of the undertaking are the undertaking's knowledge and state of mind without more. And so what the Tribunal is making clear is that one doesn't delve into common law principles of ostensible authority or vicarious liability. It is done simply by reference to the EU concept of undertaking. Now, in this case, no one disputes that at the time of the infringements, Allergan owned and controlled the infringer subsidiary between 29th of May 2015, 10th of March 2016, and Intas owned and controlled the infringer between 9th of January 2017 and 31st of July 2018. So the infringing undertaking and who's in it is undisputed. Now, what flows from that, in my submission, is that all of the entities in that undertaking are liable. And can I just show you one authority that sort of supports that submission? It's at tab 28 of the authority bundle at page 7.
So we have a single undertaking, different ownership, 2 different principal periods.
Yes, my Lord.
When you say all entities are liable, what do you mean by that?
My Lord, I should clarify and be more precise. All entities within the undertaking are liable for the time period in which they are part of the undertaking. So I am not saying that Allergan is any way liable for the period of ownership by Intas or vice versa. It is driven by the period of ownership. That is important clarification, my lord.
So all entities within the undertaking
Yes.
are liable for the time period for which they are part of the undertaking.
Yes, my lord, and I've given you the time frames for when that is true for Allergan and for Intas. And then there's an important consequence, and it's spelt out by the General Court in the Carbonless Paper Cartel. It's Authorities, tab 28, page 761. It's paragraphs 51 and 52. I just want to show you this. In 51, thank you, you'll see the argument was being made by the appellant there that a penalty should be specific to the offender. It was the parent appealing. And the court says, no, that you've misunderstood the basis of liability of a parent. It's not strict liability. It's actually your own liability, and it's personal in nature. And in 52, the court goes on to explain how competition law identifies the personal liability of the undertaking as the economic entity, and that even if the parent doesn't participate directly in the infringement, but it is part of the undertaking, the liability of the parent is not strict liability. And then in the last 3 to 4 lines, in that situation, the parent is penalised for an infringement which it is deemed to have committed itself. And so to foreshadow what I'm going to submit is that what matters in this case is that Allergan, during its ownership, and Intas, during its ownership, were part of the same undertaking as Accord UK. It was the marketing authorisation holder. It was the one that knew its costs, its prices, its profits. It knew its product. And as I'm going to come on to show you, that is what matters when it comes to the question of intention of the undertaking.
Sorry, just dwelling on 52, I suspect we had this in VW. So the analysis is that the entire undertaking is liable on a joint and several basis.
Yes, my lord.
And that is not to be treated as strict liability because the controlling companies within the undertaking are deemed to be in the same undertaking because they decisively control the infringing party.
Yes, my lord.
So it's an explanation of why it's not strict liability, but also confirmation that it is joint and several.
Yes to both of those points. And moreover, that the parent can't simply say, well, I knew nothing, or I wasn't involved.
Well, it can say both of those, but because it's joint and several liability, they are liable, and it is not strictly liability because by definition they control.
Yes,
they're responsible. It's attributed.
Yes. And as my lord observes, that is what this court held by reference to the Grand Chamber's Court of Justice judgment in Sumau in the trucks case, where there too it said, what you need for there to be liability is that one legal entity infringes, here, or Accord UK, then you identify who's within the same undertaking as that entity, here, Allergan for its ownership, Intas for its, and then they're all, as my lord points out, jointly and severally liable.
And then you go on to say, for the purpose of penalties,
yes,
you then look to see at what point in time they were in the undertaking.
Yes, my lord, and I'm going to come on now to address the question of intention, what's meant by that and how it's established for the undertaking, because that's what Parliament has provided. And can we pick this up in the decision, please? Paragraph 10.15 on page 1619 of the core bundle. And we actually saw this, and as my Lord Justice Flaux pointed out at the time, this sets out the test, and indeed was the principles laid down by the court in the Ping case. So that's the legal test. And the important point there, of course, is that it doesn't matter whether you're aware of illegality. So the fact that Mr. Stewart or Dr. Burt weren't aware of anything illegal does not matter. But my Lord Justice Green asked, well, what is meant by intention? What facts are relevant? And the CMA addresses that at paragraph 10.20 over the page, please. And what we can see here, thank you, is that the case law is clear that you'll be aware of the anti-competitive nature of the conduct, where it's aware of the essential facts that underpin the legal finding of abuse. So you don't need to know anything about the law, you do need to know the facts. And just to draw your Lordship's attention to the lengthy footnote 3509, this is not new law. This dates back to the Michelin case, where the Court of Justice adopted exactly that approach. And you can see the list of authorities that are set out there. Now, what I would like to do next is to show you what the CMA found in terms of those essential facts, and that begins at paragraph 10.21, please. Yes, thank you. And you'll see here that it makes a finding that the undertaking knew or should have known the essential facts relating to, one, it was a dominant undertaking. Can I just pause there? My Lord Justice Green, in my submission, rightly pointed out that that is not a reference and cannot be a reference to dominance in its legal sense. Must, of course, mean the facts that underpin the finding of dominance. So perhaps a better word might have been a position of market strength or economic strength. And then secondly, that the prices were unfair.
What, appreciable market power over price?
Absolutely, my Lord, that would also do the trick.
I mean, Ping was a case on a selective distribution agreement, and it was an object case.
It was.
So you're looking at you can't just apply the formulation of the Court of Appeal in Ping. In this case, you've got to change it because you're dealing with abuse. So you're not looking to see whether or not a prohibition on the use of the internet is likely to harm competition.
No, that's
different essential facts.
Exactly right, my Lord. So a bit of common law pragmatism to sort of adapt that and sort of say, cannot be unaware of the exploitative nature of the pricing imposed by, as my Lord puts it, a firm that has appreciable market power. And what I'd like to do very briefly, if I may, is just to show you some of the essential facts, the underlying evidence that was relied upon by the CMA. It has been suggested in submissions that the CMA didn't find intention. In my submission, that is manifestly incorrect. The CMA's finding was that these infringements were committed intentionally, you can see that from paragraph 10.8, or in the alternative, negligently. So there is clearly a finding of intention. But if I can show you the evidence, it begins at 10.25, that's on page 1623, please. And in my submission, what I'm just to foreshadow where this is going, can we go back to the top, please? What we will see is the evidence being set out by the CMA, and what we will see is that it takes a phased approach. No one's ignored or left out. It's sometimes been said that the CMA had a blind eye to the Intas period. We're going to see some documents in reference to Intas relevant to the question of intention. So we start then with paragraphs A to C. That relates to the awareness of monopoly during what the CMA calls period A1, the tribunal calls the Patel phase. And it's very clear they're the only supplier and they have a market-leading position. So clearly they knew they had market power. Then in subparagraphs D to F, so at the bottom of the page, please, we move to period A2. This is now the Allergan phase. And can I just ask you to note the unvarnished truth of the observation made by the senior vice president of Octavis. This is during the Allergan era, where they say, and you see it in paragraph E underlined, currently in the UK, we have all the market. Well, if you've got all the market, then clearly there is no concern about anyone that is competing with you at that time. And over the page, we see an even bolder statement, if one can actually imagine that, at paragraph F, 100 plus, 100% plus is what they were regarding themselves, January 2016. So again, within the Allergan ownership period. And now to the Intas period. And we can see this is being picked up in subparagraph G. And this makes 2 points. One, which is the second point, halfway down, there is a continuity of senior individuals. So the personnel involved at the highest level, Mr. Wilson and Mr. Kelly, they remain in place. They knew of Auden's efforts to protect its market position. So there's the human continuity point. And two, Intas was specifically contacted by the CMA about its concerns of abuse of dominance. Now, can I just show the court exactly what the CMA did and therefore what exactly Intas was aware of at the time? It's at paragraph 9.202, subparagraph A, and that's at page 1545, please. And this is going to be a recurring aspect of my submissions in relation to Intas. So it's 9202A. Can we go back a page, please? Thank you very much. Just pause there. So, thank you. So what we see is that the CMA finds that Intas and Accord did encourage, facilitate or oversee the 10 milligram abuse. And then halfway down we see that it's relevant that Intas and Accord were made aware of the CMA's investigation. By the time of the acquisition, so that's by January 2017, the pricing of the drug had been under investigation, over the page please, for almost a year. We see a reference back to the human that we had identified previously, Mr. Wilson. He's the managing director of Accord UK. He attended state of play meetings on behalf of Accord UK in 2016. So that's before the Intas period occurred, but he stays during the Intas period. And then this, and a statement of objections was sent outlining the CMA's provisional conclusions there was unfair pricing. That was addressed to Intas in August of 2017. That is right in the middle of the Intas period. They had an SO. Now, how do they react? Well, they don't do anything. They don't change their pricing, they just carry on regardless. The suggestion was made, day 2, page 20, that somehow the CMA contacted Intas, but that couldn't have covered conduct from January 2017. In my submission, that is factually incorrect. They were on notice of the investigation, they had met with the CMA, but more than that, they were an addressee of a statement of objections in August 2017, setting out the provisional case on abuse of dominance. And in my submission, that is squarely relevant to the facts that are relevant on the question of intentional infringement. Can we go back, please, to paragraph 10.28 on page 1625? I'm going to turn to the essential facts underpinning the finding of unfair prices. And here too, I'm going to submit that we walk through the phases of the abuses. Subparagraph A refers to the phenomenal price rises during the Auden, or the Patel, and the Allergan eras, between 2008 and 2016. And I do accept that does not apply to the Intas period. So that is not addressed to the Intas period. But subparagraphs B and C are taken together, and they make the point that my Lord Justice Green made yesterday, that where we look at the undertaking, that's what Auden activist refers to, it knows its costs, its selling prices, its profits, that there was no change in the product, no investment, no benefit to patients whatsoever, and it knows all of those key facts. And then, in Roman numerals 1 to 3, the CMA refers to evidence for each of the ownership periods. Again, moving through from the interviews with Mrs. Patel and Bernard during the period A1, the Patel phase, and then in 2, Allergan's due diligence as to what it knew about the cost for patent hydrocortisone, the near-term cash cow. And then over the page, please, we see again, importantly in my submission, that of course Intas was aware of the investigation, received the SO, of course it was aware, or at the very least ought to have been aware, that a potential abuse was being investigated and indeed alleged. But there's more, because if one looks then in subparagraph D, you'll see further contemporaneous materials setting out the due diligence that was carried out. Those apply to Allergan. And so, in my submission, when one looks at this, and there is the final paragraph that in 10.29 the CMA says, at no point did the firm ever have regard to the interests of the paying customer, the NHS. Looking at that in the round, that is the body of factual material that underpins the finding that the undertaking intentionally committed the infringement. Many of those facts are ones that were within the knowledge. Indeed, Accord UK was selling hydrocortisone tablets. But it's not necessary in my submission to stray and root around to find knowledge on the part of senior individuals or indeed parent companies. Now, against what I've just said, the appellants say, well, Mr. Patel left in May 2015, Allergan relies on Mr. Stewart's lack of knowledge in his witness statement, Intas relies on Dr. Burt. In my submission, the appellants' arguments on this score are misconceived. They conflate the subjective state of mind of one admittedly senior executive in the parent company with the sum total of the knowledge of facts and matters within the undertaking based upon contemporaneous evidence and conduct and the surrounding circumstances. I mean, in my submission, it's an error of law to confuse the intention of the undertaking with the knowledge, the state of awareness of one individual. And there are two authorities that support my submission. The first is, as my Lord Justice Flaux will recall, this court has approached a similar argument in the context of establishing an anti-competitive agreement. My learned friends took you to the outcome of that judgment, but can I take you to a passage in the judgment which is squarely relevant to the submission I'm making? It's Authorities, tab 57, page 1745. And I do admit that the submission is going to be, I have to draw an analogy between what the court did in this judgment and what I'm putting to you.
Yeah.
But as a matter of principle, it is, in my submission, correct. So it's paragraph 111. And if we go down, please, thank you. And you'll see that the central point was being made, echoing submissions made on behalf of Auden Accord, that where one of the key individuals leaves the undertaking, then there can't be an agreement. And you see this. The company submit as a matter of law that a common understanding can only persist where there's a continuing meeting of minds. And the court unanimously says they don't agree with that. And they say evidence of a subjective state of mind of the parties to an anti-competitive agreement is not required. In my submission, the same is exactly true for establishing intention of an undertaking. Here it goes on to say an anti-competitive agreement can be inferred from all the circumstances and the evidence. And again, my submission is that that is exactly the same for establishing intention of an undertaking. But there is also authority relating to the inference of intention, and that one doesn't need subjective states of mind. And that goes back to the tribunal's very first Chapter 2 case, in the case of Knapp. We go to that, please. It's Authorities, tab 7, page 380. This is chaired by Sir Christopher Bellamy, as he then was. And what you will see in 456 is the last 6 lines. While in some cases the undertaking's intention will be confirmed by internal documents, or we've seen some of those in this case, in the absence of any evidence to the contrary, the fact that certain consequences are plainly foreseeable is an element from which requisite intention may be inferred. If a dominant undertaking pursues a certain policy, which in fact has or would foreseeably have an anti-competitive effect, it may be legitimate to infer that it is acting intentionally. In my submission, what one has in this case is a dominant undertaking pursuing an exploitative policy to push prices up to abusively high levels, unfairly high levels. That was clearly what it was seeking to achieve, and in fact did achieve, and though it's legitimate to infer that was done intentionally. Now, yesterday, counsel for Auden Accord sought to sort of distinguish what I'm saying and say, well, actually a temporal point is being made and hadn't been addressed, and said there was confusion on the part of the CMA. And that actually what really matters is that Mr. Patel, the owner and founder of Auden, when he left the company on the 29th of May 2015, he walked out the door and took intention with him. Now, my response to that is that AM Pharma, which is the hydrocortisone business, it remained, and there were individuals that knew the cost, the price, the profits, the product. They all remained. And in September 2015, there was a reordering within the organisation where the business was transferred from AR Pharma to Accord UK. And the infringing subsidiary continued with all the knowledge of its cost, price, profits. And those are the essential facts that underpin the finding of intention. So the fact that Mr. Patel's gone to Hawaii does not in any way detract from the infringing subsidiary and the individuals that ran it knowing the essential facts that underpin the finding of intention. And that is actually part and parcel of the concept of undertaking, but it doesn't attach what in my submission is unwarranted prominence and importance to a particular individual and what he or she happens to know at a particular time.
Just in terms of the, I think you showed us earlier, some of the personnel remained the same.
Yes, my lord.
As notwithstanding the change, the transfer from AM Pharma to Accord.
Yes, my lord. That was Mr. Jonathan Wilson, the managing director of Accord UK, and Mr. Kelly. Yes, my lord. So there is that as well, that there was some continuity of individuals.
I'm so sorry to interrupt, just because it's my point. The question that my lord asked was in relation to the transfer from AM Pharma to Accord UK, not from Accord UK to Intas.
Yes, it was.
Yes.
So the question was, I was asking...
Oh, I do apologise.
No, I'll make it clear, but from AM Pharma to Accord UK, that the internal... What was a transfer from one subsidiary to another subsidiary? Was there any continuity of personnel at that stage?
What later?
Can I just take instructions in relation to that? So, to the best of my understanding, the answer is no. There was no continuity at that stage.
It's with once you get to Accord UK.
Yes.
Despite the transfers of
Yes.
ownership of the parent company and other, it's the same individuals, Mr. Wilson and Mr. Kelly.
Yes.
That's what I understood you to say.
Yes, that's what I was saying.
The transfer from AM Pharma, the Patels,
Yes.
to Accord UK
Oh, yes.
did not
Yes.
involve continuation.
Yes. Yes. But the point that the CMA made in its decision is it wasn't as if the Mr. Wilsons of the world were somehow ignorant of what Auden had been doing, and nonetheless the point I make remains a good point, which is the knowledge of what matters, the essential facts underpinning unfair prices, that does exist, and that is the answer to the fact that Mr. Patel's not there. That doesn't detract from knowing
You have to
what
identify
matters.
your essential checklist of facts first, and then you have to ask yourself, institutionally, what did the undertaking know? So, in an abusive pricing case, it knew its costs, it knew its margin, it knew whether or not there was incremental costs incurred by way of development or innovation, and it would have institutionally know whether or not it, by looking at such matters as whether it was the only supplier, who its competitors were, what its market share was. Those and similar facts are the essential facts for an abusive pricing case. There may be others, but they're in that orbit. So
Exactly
what
right, my
Mr.
lord.
Patel knew about an external agreement might have had some impact upon barriers to entry for a period of time. But elsewhere, even if no one else in the undertaking knew that, they would still know what their market power was and who the possible entrants were, and so on.
Exactly right, my lord. So in relation to the 10 milligram agreement, the way that the CMA approaches that is to sort of break it down to sort of three elements. Was there knowledge of the fact that Waymade for the 20 milligram agreement, Amco for the 10 milligram agreement was a potential competitor as a matter of fact in terms of perceptions, in terms of how they were operating on the market, and then looking at whether there was a payment, a transfer of value. I'll come on to that later this afternoon in terms of considerable value from the incumbent to the potential competitor. And then thirdly, whether or not that brought about a delay to the independent efforts of the new entrant, which indeed, as a matter of fact, it did. And so those are the things that matter. The idea that intrigues competition lawyers about pay for delay agreements and whether they're legal or illegal, that would be completely irrelevant to this question. So, my lord, the orbit, as you put it, is indeed right. The one I would add to that list is, of course, any evidence in the internal documents of a strategy at all, in terms of an appreciation and awareness of being able to exploit being unchallenged from the competition. And in my submission, the same point applies to Mrs. Stewart and Dr. Burt. Of course, they did deny that they knew about any wrongdoing, and it's been repeatedly pointed out that we didn't challenge those witnesses. We didn't need to, because my Lord Lord Justice Zacaroli observed on day 2, page 86, Mr. Stewart, for his part, restrained submissions about disagreeing with evidence relied on in the CMA decision. But regardless of whether those senior individuals, taken at face value, they didn't know about the illegal behaviour, that doesn't gainsay or detract from the undertaking knowing the essential facts, which I have shown you by reference to the evidence in the decision. I'm going to turn to the tribunal, which, it is fair to say, cuts to the chase. And can we go, please, to page 471 on this issue?
Euphemism, it was short.
My lord, yes, it had the triple virtues of being clear, concise and correct. If we start with intention,
Hang on.
so it's
Hang on.
paragraph 376, subparagraph 1, down the page, please.
Yeah.
And you'll see that the second sentence, the tribunal considers the infringements were entered into intentionally, and then it identifies 3 sets of circumstances that go to that issue. Firstly, that there was an extreme mismatch between cost and price, so a fact very similar to what the CMA had found. Secondly, any business person would have understood that there is, in this case, if you go over the page to show the court, an absence of any legitimate means of differentiating Auden's product from the competition. So there's no explanation, even a putative justification for this extreme mismatch. And then the punchline in the last sentence, that it arose out of a legitimate exploitation of regulatory weakness. And in my submission, it's important with the judgment to sort of not read sub-paragraphs or sub-paragraphs in isolation. If one goes back to 354, please, on page 464, this is under the heading to do with uncertainty. Go down the page, please, or lack of clarity. And what we see in subparagraph 1, in my submission, is relevant to what the tribunal goes on to find in 376(1). Because what we see here is the tribunal, A, saying the law is clear. My respectful submission, that is correct. B, saying all of the undertakings holding the marketing authorizations to the focal products, so that is Auden activists, would have been well aware of both the cost and the price charged for those focal products, same points to the CMA decision, and then they would have been aware that the latter price significantly exceeded cost. And again, that is also, in my submission, relevant to the facts underpinning the finding of intention. So when you take 376(1 together what's said in 354(1, in light of what the CMA had set out in its decision, which I've showed you, my submission, that is more than ample to justify the finding of an intentional infringement. I'm going to move on, if I may, to my third topic, which is the tribunal's independent assessment. And this is the failure to address argument. Can we start, please, at 357 on page 465? Just in terms of what the tribunal directs itself. It says here, 3 lines down, that they must review the penalties imposed with an independent mind. So it is saying that it's got to come to this, as indeed it must, under paragraph 3 of Schedule 8 of the Competition Act, to look at this independently and afresh. And then if we move, please, to paragraph 374 on page 471, as my learned friend, leading counsel for Auden, rightly in my submission pointed out, the tribunal here sets out the approach so that it has 2 tasks. The first of which is to review the CMA's application of the guidance, the second of which is to make its own broad brush assessment of the penalties. And for your note, that was endorsed as an approach in paragraph 163 of this court's judgment in Argos and the OFT, at Authorities, tab 16, page 522. And I'm going to address each task in turn. As to the tribunal's first task, in reviewing the CMA's application of the guidance,
What's
what
meant
we
by
do...
broad brush? I remember Argos very well because I got panned in it.
Not doing well this afternoon, citing a whole load of authorities who
Who were duffed up.
I'm sure it happens to the very best of us. And in terms of what does broad brush mean, my submission is that it's an independent overview or in-the-round assessment of the relevant features of the case. And we're going to see broad brush when I come on to the second task.
Does it mean lacking in detail?
My lord?
Does it mean lacking in detail? Or
Well, hopefully having the virtues that I identified of being clear and concise. But it means you don't need to get into the minutiae. You can look at the big picture. My lord?
You might do.
You might do. Some tribunal panels have, and this one decided to take a slightly broader brush approach than other tribunal panels. In terms of the first task...
Not the broad axe, this is the
It's not a broad axe, it's a broad brush.
brush.
what the judgment does is it sets out the CMA decision in quite some detail from paragraphs 358 to 372. I'm not going to go over that now, but that then informs in my submission what is then said in 375, where the tribunal says we see nothing in the CMA approach amounting to material error. And for your note, it goes on to say something similar in 376 subparagraph 3 over the page. There is no getting away from the fact that the tribunal did not explore the CMA's approach in a granular manner. In my submission, either the tribunal should be taken to have endorsed and adopted the CMA's reasoning and conclusions on the penalty guidance, or, in the event this court considers the tribunal failed to address some of the appellant's arguments, then the CMA invites this court to uphold the order of the tribunal for all of the additional reasons set out in paragraphs 8 to 14 of our respondent's notice.
Can I just ask you about that as a point of principle? That one of the reasons you have an appeal, particularly on penalties, because they are, as everybody knows, it's almost like quasi-criminal. They're big. Penalties are big.
They are big.
And, the CMA isn't a court. Therefore, there has to be effective supervision by a court for Article 6 purposes. And if the appellants have put forward arguments, and we haven't seen the schedule yet, and we'll come to that, but if arguments have been put forward and they're at least, respectable, they're not silly, aren't they entitled to have them aired at least?
Well, my lord, they did air them, and there's been reference to the number of pages on that side of the court.
We'll see what they look like and what the nature of them are in due course.
And the CMA obviously answered them, but actually what I will come on to show you is that many of these arguments were not new. They were arguments raised and were squarely addressed by the CMA in its decision.
But that's rather the point, isn't it? That the appeal is against the decision.
Yes.
And it's for the CAT independent to decide whether those arguments are right or wrong, not to, unless there's a clear endorsement, proper endorsement of an analysis of those arguments in the decision, in which we can say with confidence, inferentially, they've been properly addressed.
Yeah.
Aren't the appellant entitled to have them aired? Because
even if the tribunal had only said we've read these schedules, we haven't felt it necessary to address them specifically. We have considered them, and they seem to us to simply repeat arguments that were made before the CMA, and we agree with the CMA. And if the tribunal had said that, then the appellants would be on much weaker ground.
Well, my lord,
they didn't even do that.
Well, my lord, if we just go back a page, please. Well, in 3742, obviously taking the tribunal at its word, it says, we've taken full account of the submissions made by the appellants. We don't set them out in detail, because our starting point is the CMA's approach, whether that approach is or is not defensible. It sets out the CMA's approach in considerable detail, as I showed you in paragraphs 358 to 372. Yeah. And then its conclusion is indeed in 375, there is nothing in the CMA's approach amounting to material error. Now, on my Lord Justice Green's point, which is about airing...
They relied upon some pretty dodgy authorities in line 1 there, didn't they?
Well, I mean, other good textbooks are available online and in shops.
Sorry, I'm only teasing.
I know, my lord, I know. It's all good.
Procedural fairness point. I hate to come back to
Well, so my lord, on the procedural fairness point, I am reminded on my feet, and we can take, it may not be in the authorities, but a similar argument was run by Welsh Water in the Albion Water case, and the argument was put, how dare the tribunal find dominance for the first time when the water regulator had not made any such finding, and whether it had any jurisdiction to do that, and that therefore effectively it skipped some of the valuable procedural safeguards in the process, particularly a statement of objections and things of that kind. And in the Court of Appeal, Lord Justice Richards indicated that provided the tribunal acts fairly, and in that case it was found to have acted fairly, there's nothing to stop it from making that sort of finding. And in this case, the tribunal has set out the CMA's approach. the tribunal has reached a clear conclusion in relation to there being no material error. And what the CMA is saying is either it's endorsed the CMA's reasoning conclusions, which I'm going to come on to address you on in relation to the other grounds of appeal, or the CMA is entitled, if the lower court hasn't quite discharged its duty in the way it ought to have done, to invite this court to uphold that order for additional reasons. And looking at the authorities like Embrace Yourself, for example, that's exactly the proper role of a respondent's notice in my submission.
But the respondent's notice largely reflects the points in the decision.
Yes, my lord. It entirely reflects. Entirely reflects.
Then I think our concern, we haven't formed a definitive view, but our concern is somewhat more structural.
Yes.
You're an administrative body. You can
Yes.
impose swingeing fines of hundreds of millions.
Yes.
The chance for the appellants before a court, the first opportunity, court or tribunal, is in front of the CAT. So the CAT is the first time it's the first time a review of a quasi-penal provision. And the question is, what do we expect of the CAT in those circumstances? Is it enough, in almost boilerplate terms, to just say we endorse a CMA, given we're looking at hundreds of millions of...
My lord, that is an entirely fair point. And of course, that isn't exactly what the tribunal did, because there were two tasks. And actually, in my submission, the much more important task was that it brought to bear its own independent view as an independent specialist tribunal and exercised that jurisdiction. In my submission, it did do that. It took a step back, it looked at it broad brush, and it came to its own view, and it didn't mince its words about why substantial penalties were appropriate in this case. So in terms of, did they have their opportunity in court to address an independent tribunal, and did the tribunal then reach its own independent conclusions, quite separate from the CMA's decision? My submission, it squarely did. And I want to address you on that second task, because arguably that's the more important.
Okay. I'm not going to go on about it. We've expressed our concern.
My lord.
We'll hear you, and I'm sure the appellants will spot a bandwagon and jump on it.
I'm sure they will.
But I mean, it's just something which is going through our mind at the moment. We really haven't yet formed a definitive view on it. And we're interested in the extent to which arguments were raised, not necessarily their merit, just to get a feel of the sorts of issues that the CAT didn't specifically grapple with, which we'll come to in due course.
My lord, it is common ground that there was extensive argument on both sides in relation to penalties. If you look at the amended offence, you will see hundreds of pages relating to penalties on the CMA side. So it was fully argued. And if I may develop the point on the independent assessment, because one of the criticisms that's made is that, well, the CAT didn't even show up and reach an independent view. And my submission that is wrong. If one looks down in 375 and then 376, what one sees is in the last four lines of 375, in my submission, an entirely independent and eminently correct description of the infringements. Extremely serious, protracted, significant economic harm, significant economic benefit. Hence, the tribunal thought, in its own view, that a substantial penalty is to be expected. That's not relying on the CMA's decision. Indeed, as I've said elsewhere, there are features here that derive from the tribunal's earlier conclusions in the judgment. So as to the finding of extremely serious, it goes on in 3761 to talk about the extreme mismatch between cost and price. We go over the page, please. 3762, the tribunal does not hesitate to say the record of the appeal, last two lines, demonstrates very clearly an illegitimate exploitation of market power to leverage price well in excess of what was fair. Earlier in the judgment, we don't need to turn it up, but I'll give you the reference. Paragraph 333, page 458, the tribunal held, it is plain to the point of irrefutability that Auden activist prices were excessive. And we saw the passage in 354 that I showed you, that each of the holders of the marketing organisations within the Auden activist undertaking were aware of the price significantly exceeding cost.
But even if these are absolutely taken as a given, at least some of the appellant's arguments are about how that then turns into a figure.
Yes, my lord. And And then that is where, essentially, as far as the CMA is concerned, I have the 2 paragraphs. I've tried to show you some of the earlier findings. I'm going to address you on the respondent's notice points. Yep. I do take the point that the appellants are entitled to have their day in court and entitled to have their arguments heard and determined. Here, the tribunal has clearly said no material error what the CMA had done. I mean, the thought experiment could be, well, imagine that the judgment were another 100 pages and they set out each of the arguments in a sort of laborious detail, and then each time they then set out the CMA's reasoning and conclusions, and each time very carefully saying, well, we agree with the CMA about that. That would have been them going through in a much more, it wouldn't be procedurally kind of economy, but it would go through each of them. My submission doesn't necessarily add very much in terms of that review of the CMA's application of the guidance.
At least we would then have had full reasons, and we would have known what their position was on each of the arguments. At the moment, there is at least a risk that it feels like a boilerplate response.
I think the difficulty is in really picking up on Lloyd's last point, is unless there's something other than the sort of general saying we agree with the CMA's approach in 375 and 376, which is pretty solid, then the issue is, well, is that really good enough? Have they actually, does that demonstrate that they consider each of the arguments in turn and concluded the CMA is right on that argument? Now, you're absolutely right. Setting it all out in 100 pages might not have been appropriate for this. One would normally expect a little bit more than this.
My Lord, I entirely see the force of that observation in relation to the tribunal in terms of what should be expected, providing clear, intelligible reasons.
This is a very, very detailed and long judgment, and looking at it, being blunt about it, I had the impression when I first read this that they simply sort of got fed up and ran out of steam when they got to penalty.
I couldn't possibly.
Everything else is dealt with in an incredibly detailed way. But then penalties is
it is more compressed, unquestionably so. Yeah. I'm going to address the court with the rest of my submissions relating to the CMA's position. We addressed the arguments. They were not new arguments. We do rely upon them in this court in the respondent's notice. It means that they've had now 2 bites of the cherry. We're responding on the 2nd bite of the cherry in this court, and we say that the order that was made by the tribunal was the right one for the reasons that the CMA gave. If this court were minded to give guidance to the specialist tribunal as to what is expected of it in terms of reasoning in penalty appeals, I'm sure that would be gratefully received by all parties going forward.
Yeah. I mean, you do address us on the respondent's notice, but as I read them, they're largely reflecting the position taken in the decision, and we recognise that's fulsome. But in one sense, that's not necessarily the point, because it's that fulsome analysis they're entitled to challenge before a court, to have an independent review of, rather than the tribunal simply say, with a bit of a sideswipe, yeah, that's all right. That's really the issue. It's not that your decision may be wrong, or that your respondent's notice isn't fulsome and isn't thorough, detailed, doesn't address the points. It's what's the cat's answer to them?
The cat's answer was that the CMA wasn't a material error.
Yeah.
And I'm going to now show you that and the responses that we make to the appellant's arguments. I don't wish to avoid or speculate on the
you'll come to it in due course, but we were asking yesterday for discussion between the parties so that we had a better feel for the nature of the arguments that were put and were not addressed. Have the parties had a chance to...
The appellants haven't spoken to, well, as far as I'm aware, to the CMA, but I imagine they've liaised between themselves. Perhaps the appellants could.
Well, maybe we'll come back to the end. I mean, there may well have to be some further consideration as to how we deal with penalties. I mean, do you want to deal with it at the end?
My Lord, I can certainly address you at the end on it.
We're going to move on to attribution, if I may.
Yeah.
And I'd just like to answer my Lord Justice Green's question about the moment at which the analysis moves from the addressees of the competition rules to the addressees of the decisions. That was at day 2, page 32. Yeah. Can I do this, please, just by reference to the an annex to the CMA's decision? And so I think it's just helpful to see all the steps in one place. And so the core bundle, volume 5, tab 26 at page 1841. And I'm just so that you can see all the steps on one page. And what I'd like to do is just explain how the CMA approached this issue. So as we saw in the statute, it is referring to the infringement committed by the undertaking. And if we start first row, step 1, starting point, that is on the seriousness of the infringement and general deterrence. So that is focusing on the undertaking's infringement. And then we go to step 2, in the third row, that is dealing with the duration of the undertaking's infringement. And then if we move to step 3, that is dealing with aggravating or mitigating factors of the undertaking's infringement. And then the moment, at least as far as the CMA was concerned, that it moves from the undertaking to the legal entities that will be required to pay the penalty is at step 4, and you can see that in the orange row. And, my lords, this is explained by the CMA in paragraph 10.135 of the decision, page 1661, because what the CMA does is it apportions the penalty according to who owned the infringing subsidiary. And it did that for 2 reasons: to reflect the EU principle that a penalty must be specific to the offender and the offence, and it did that also to reflect the minimum financial benefit of these infringements. So it's at that point we then start to address the position of the legal entities. And then just to complete the run, step 5 is the statutory cap, to which I will, yes, my lord. Step 5 is the statutory cap, to which I'm going to come in relation to Auden Accord submissions, and step 6 is not relevant here. No one sought leniency or settlement. My lords, I'm going to move to my next topic, which is specific deterrence and proportionality. And I'm going to start with the law and the proper approach, if I may, and just briefly show my lordships the court's judgment in diethyronine, which gives a very helpful overview on this point. I'll take it very, very shortly. Authorities, tab 61, page 2082. And we pick it up, please, at paragraph 205. And this sets out Parliament in 205 requires the CMA, when fixing a penalty, to have specific regard both to seriousness and the desirability of deterrence. That's what Parliament has laid down. You see in 206, the guidance also has the objectives of reflecting seriousness and deterrence. We go down to the next page, please. And in paragraph 209, we see the key paragraphs that are relevant at step 4. And I'm not going to read them out, but they are all going to be relevant to the submissions I make. What I would do is draw 3 highlights from this. First, and you can see this from the opening sentence of paragraph 2.20, the assessment of specific deterrence and proportionality is for each addressee of the decision at the time the penalty is imposed. So in this case, that was 2021. And second, this is a multifactorial assessment. And you can see that because there are various factors that are set out in these paragraphs. Just to name check some of them, we'll come on to it. The undertaking's size, financial position, the nature of the infringement, the role of the undertaking, the impact of the undertaking's infringing activity. And in my submission, the CMA considered all of them in its decision. Now, contrary to Allergan's submission, this is not a mechanical exercise, nor indeed is it a mathematical exercise capable of producing a single right figure. If we look at, just go down please to paragraph 2.24, what the CMA does at this step is it looks for the factors on specific deterrence, and then once it has decided that issue, you'll see at 2.24, it looks at the overall penalty in the round, looking at all the factors that are listed there in paragraph 2.24. And really, this is an exercise of judgment. And the tribunal itself has recognised this point in an authority I would like to show my lordships, which is McCann and the CMA.
Before you move on, can I just
Yes, my
ask
lord.
you what you understand the reference to undertaking there in that section is?
Yes, my lord. So it is a little confusing, but the undertaking there is referring to each of the addressees
The entities.
of the decision. Yes, my lord. Yes, my lord. Of course, they are themselves undertakings because they're at a different point in time. So Allergan, for example, is an undertaking. It just no longer owns and controls the infringer. My lords, if I could just take you to one tribunal authority. It's McCann, Authorities tab 49, page 1316. To show you a couple of passages relating to this step. Because in my lord, we go down please to paragraph 312. There is a useful explanation here that when it comes to step 4, you can see the points that we've just been talking about, the various matters that have to be considered in the round. The tribunal says on the question of proportionality, those are questions that involve matters of evaluation or judgment. In my submission, by their very nature, they do not lend themselves to elaborate explanation. If we go over the page, please, to paragraph 314, you'll see that the CMA in this case gave clear, adequate reasons, not more required. Ultimately, the figure at step 4 has to be in the round. There's no single right figure. And again, evaluation and judgment. What matters is what figure feels appropriate, taking account of all relevant considerations. Now, going back to, without reopening that debate, but going back to the debate we had about the tribunal's role, my other submission I would make is that what matters is that the figure that the tribunal ultimately arrived at was appropriate. There is clearly an issue as to whether the tribunal gave adequate reasons and addressed various specific arguments made by the appellants. But what ultimately matters is did it set out, admittedly in clear and concise terms, whether the overall figure for the penalties were appropriate. And with that in mind, I'm going to move now to look at each of the infringers, Allergan, then Intas, and then Auden Accord. With Allergan, just to note at the outset, its original fine for the 10 milligram abuse was 74.3 million. On appeal, and this is common ground, that was reduced because of the period in which it owned the infringer to a sum of 49 million. So just to bear that in mind as we look at the findings made by the CMA. Can we pick it up, please, at 5 matters which the CMA took into account in relation to the deterrence uplift for the 10 milligram abuse, and start at paragraph 10.260 on page 1707. And this is the first matter which the CMA took into account. One set, no, not in the authorities, please, the core bundle. Thank you. The first matter that the CMA took into account was the minimum financial benefit. You scroll down for the table, please. And for Allergan, period A2, and I can give the court the adjusted figures, the step 3 penalty remains the same, 6.8 million. The revenue above the £20 per pack enforcement price, the minimum financial benefit, for the adjusted period is 26.8 million, and the differential above cost plus is 36.8 million pounds. The underlying principle here is that a wrongdoer shouldn't profit from its wrongdoing, and therefore the very first factor justifying an uplift in the step 3 penalty is that to deter, the penalty should exceed the ill-gotten gain. So that's the first matter taken into account by the CMA. Secondly, we turn to page 1709, please, paragraph 10.267. Go down the page, thank you. Is the serious harm that this infringement caused, both to the NHS and patients. Just to put this in context, the abuse drove up NHS spending on hydrocortisone tablets from £500,000 in 2007 to 84 million in 2016, the year in which Allergan owned the infringing business. And there's a really helpful table in the decision showing how NHS expenditure changed. Can we look at that, please? It's at page 1169. Thank you. You can see the table as how we go from 0.5 in 2007 to Allergan buys the business in 2015. So we're now at 70 million. Year after, 79 million. And I'll come back to, well, just while we're here, the Intas period, just to take it in, 58 million for the 10 milligrams, so 62 overall, and 39 million overall for the NHS expenditure. If we go into the next page, please, you'll just see that diagrammatically, and in my submission, the bar charts speak for themselves. Now, yesterday, counsel for Allergan said it's irrelevant that the NHS is a national treasure, but that misunderstands the point the CMA is making. It's not because it's a public body that this is relevant. Quite simply, it's because the NHS is being ripped off for a 60-year-old tablet. Now, my lords, the third matter, which is one that you were shown yesterday, is the size and the financial position of the companies. And can we go to that, please? So page 1711, to which Allergan referred to this as the Bigley point. And this is the prodigious size of Allergan. And it was said yesterday there was an error because the CMA had relied only on turnover, and you were taken to Kia and to Deutsche Telekom. We can see from the face of the decision that the CMA didn't rely only on turnover. In fact, we see, and it is worth dwelling on the figures, £35.7 billion. That's a lot of zeros. 3.6 billion profit after tax, 9.6 billion net assets. And the punchline is, as is set out here, the Step 3 penalty for Allergan is minuscule. It is, in the words of the life-threatening judgment, paragraph 238, it is de minimis. It is no way going to deter. And you can look at it, turnover, profits after tax, net assets, whichever financial metric you so wish, 3-year averages, as well as the year before the decision, this would have no impact on the undertaking. It would not deter. And so that, in my submission, is a very important justification for, but not the only justification, for the deterrence uplifts. There are two other matters, neither of which you were taken to yesterday, but both of which are relevant. And we see the first of those, this is my fourth point, at paragraph 10.273. Allergan earned a significant amount of its turnover outside the relevant market. Now, this is expressly referred to in the penalty guidance at paragraph 2.21. The reason why it's relevant to specific deterrence is that you calculate the Step 3 penalty using the turnover from the relevant market. If, as here, it's a teeny-weeny, minuscule amount of the total undertaking's turnover, it produces a fine that won't deter. It won't have any impact on the undertaking. And the tribunal, chaired by Mr. Justice Roth in Eden Brown, made that point in paragraph 90, the Authorities 27, page 748. So this is a further factor in my submission, not addressed by Allergan's counsel, but nonetheless important. And then, under other relevant factors, we see here, again expressly identified in the penalty guidance, this is in paragraph 2.22, that actually the relevant turnover used to calculate the Step 1 figure, I apologise, my lord, I'm in paragraph 10.274 and 10.275.
Okay.
And I was just going to sort of summarise the gist.
Yeah, okay.
The gist is that the relevant turnover that was used to calculate Allergan's Step 1 starting point actually doesn't accurately reflect the scale of the infringement during the period in which Allergan owned the infringer. Because actually, as the CMA explains here, ASPs reached their zenith during Allergan's ownership. And so where the Step 1 turnover doesn't accurately reflect the scale of the infringement, the guidance in paragraph 2.22 says this is also a basis for the significant upward adjustment. Now, pausing there, you have the minimum financial benefit from the infringements. You have the harm to the NHS and patients. You have the considerable mammoth-like size of the undertaking. You have huge amount of turnover outside the relevant market. And you have the fact that the relevant turnover used to calculate the starting point doesn't reflect the scale of the infringement. My submission is it's a multifactorial assessment. And if one goes over the page, please, and one more page, please, 1714, paragraph 10.288, at the bottom. This is where, at 10.288, the CMA then is going to make the adjustment. And it says 6.8 million. I mean, it's not pocket change for the weekend for Allergan. Allergan says, well, we didn't know about the illegal conduct, and we're in the US generating turnover, and we're no longer in pharmaceuticals. But my response to that is that none of that undermines the multifactorial assessment grounded in the statutory penalty guidance. All of the factors point in the same direction, and they all point in an upward adjustment for specific deterrence. Allergan also said that no one was interviewed during the investigation. But the CMA had contemporaneous materials as to the strategy and behaviour during the Allergan era. If I may just give you a very brief reading list, because of course you were given some reading from Allergan. Paragraphs 9.135 to 9.158 of the decision, pages 1523 to 1530, set out those contemporaneous materials. But none of that detracts from the need for deterrence. Now, the CMA is not in the business of using sledgehammers to crack nuts. And so if we turn over the page, please, you'll see for the proportionality assessment, the CMA then looks at the adjusted fine. So the adjusted fine in the decision is 74 million. Following the appeal to the CAT, it's 49 million. What you see here is that even when adjusted, even with the 1,000% uplift, what does it produce? As my Lord Justice Green observed yesterday, look, it's 0.2% of worldwide turnover, 0.3% over a 3-year average, 1.6% of profit after tax. It's not going to break the bank, but actually, if anything, we have been extremely conservative in seeking to adjust the fine. And on any view, my submission is this is manifestly proportionate, bearing in mind 35 billion revenue company, prices reaching their peak, Allergan pocketing 37.9 million from the abuse. Now, the CMA doesn't stop there, actually. The CMA, my Lord.
Sorry, can I just interrupt that point to go back to this question of deterrence?
Yes, my Lord.
So one of the points made is, and you dismissed it, that the fact that Allergan is no longer in this market at all is irrelevant. It seems to me there are two factors at play here. One is the fine is too small, taking into account all of its global turnover. So we must increase it so that it hurts.
Yes, my Lord.
The second is that this is in the context of deterring them from doing it again. If
Yes,
they
my Lord.
can't do it again,
Oh, my
they're
Lord.
not in the business anymore.
So, my Lord, on the first point, I entirely agree. And on the second point, I respectfully disagree, because deterrence is not addressed to the particular sector, it's addressed to the type of infringement.
Isn't that the point? It's pour encourager les autres. Isn't it?
My Lord?
It's pour encourager les autres. No,
yes.
impose it. And
Well, no.
so
So,
seen in the industry as a whole, this is what will happen to you if you.
well, no, so my Lord has described, I believe, general deterrence, which
Yeah.
is my leading counsel for Intas described as an issue dealt with at step 1. This is about specific deterrence.
This is specific deterrence about
To the infringer.
To the undertaking as a whole. Or
Yes, to the undertaking as a whole.
Right.
And my point is that deterrence is not sector specific. It relates to the type of the infringement.
Sorry, but it's the specific entity as well.
Yes, yes, my Lord. Yes,
It's
indeed.
Allergan, the entity.
It's Allergan to not commit in the future these types of infringements,
So-
namely cartels
Yeah.
and excessive pricing.
So does that, just so I understand that, what you mean by that is it's no answer to say we're no longer in the pharmaceutical business. They are still in business, and therefore this is a deterrent to them as an entity. Just stop, to know that if they infringe competition law in this jurisdiction again, this is the sort of penalty they're likely
It's
to
based
face.
on the criminal notion of propensity. If you do it in one market, you do it in another.
There's yes, as my lordship's observed in para 238 of liotharanine, there is a risk of recidivism based upon the factors that I've shown you. And my lord, you're exactly right that they're in business, and insofar as they operate in this jurisdiction, there needs to be a very clear deterrent from engaging in this very serious and harmful behaviour.
And just in terms of deterrent in relation to the infringement, not the market, where does that come from? Is that in the guidance? Or is that a gloss on the guidance? Because if it's about the market, then
So,
that
there is EU authority that relates to what deterrence affects. There is EU authority that relates to deterrence. I don't have it to hand, but I can, of course, provide you with simply the reference that talks about what deterrence applies to, because it has been considered in a number of cases, because there have been uplifts by the European Commission, and the question has become, what are you deterring? Is it all anti-competitive activity? Answer, no. Has to be of the right type. Is it limited to a particular sector? In my suspicion, the answer is no as well. But I don't have the authority to hand, and I'm not sure it's in the bundles, but I can provide it to the court if that would assist.
So if a company moved from a market where it had hitherto enjoyed market power to one which was fiercely competitive, so that there was no prospect of it engaging in that sort of conduct again, would that be relevant?
In my suspicion, the answer ought to be yes, because deterrence is forward-looking and it's all the relevant circumstances. And so if an entity comes forward and gives evidence, the evidential burden again, but demonstrates that, hey, look, I'm out of that sordid business, I'm now in a hyper-competitive market, I've turned over a new leaf, I've got a compliance programme, those could be points that could be raised with the CMA, and I think the CMA would have to grapple with them. I couldn't obviously preempt the outcome of that analysis, but I think it must be a relevant circumstance.
Appropriate mitigation points anyway.
It could also, I mean, as my learned friend for leading counsel for Intas has put, there is obviously different places in the steps. They're not mechanical or rigid.
No.
It could have come up as a point of mitigation. You couldn't take that into account. Yes, my lord. That certainly is not this case. Certainly, there's no evidence being put.
But moving out of the United Kingdom market might at least be one step in moving away from the risk of recidivism.
Well, but then there's no guarantee they're going to stay out of the UK market, is there?
No.
And in fact, Cinven was also a US private equity company that wasn't in the UK, and nonetheless, the CMA and this court agreed was entitled to increase the fine for specific deterrence of Cinven.
Can I put it this way? It's quite a complicated issue which the CAT doesn't grapple with.
The CAT may not have grappled with that issue. The CMA obviously has grappled with it, and you have my suspicion in relation to what the position is. I have an eye on the time. I'm going to move on. Oh, I did want to just add, I'll just give you the reference to it. As far as Allergan goes, there is also then, they calculate the penalties for the 10 milligram agreement. That's gone back to the CAT for hearing next January. But the CMA did look at the total penalty in the round. And again, just for the sort of, in case they're pulling at your heartstrings about proportionality, total fine for Allergan is 0.3% of worldwide turnover. The statutory maximum is 10%. Allergan owned Cartelist and owned a company that excessively priced. So in my suspicion, it clearly was proportionate when you look at it like that. Intas. So I'm going to address Intas's two central arguments. The first of which was that prices were falling ineluctably from one abusive level to another abusive level, and that should somehow be a mitigating factor. And then secondly, that Intas bore the brunt of too much of the penalties when compared with Allergan. Before I do that, if I may, could I just give you a thumbnail sketch of the 5 factors that inform the CMA's assessment of the penalty as it was adjusted at step 4 for Intas. Many but not all of the factors are the same as Allergan. So the first is the minimum financial benefits. And if we go to page 1707, back to table 10.7 in the decision, we'll see that the minimum financial benefit was 12.5 million. That's what counsel for Intas focused on. But we should also not lose sight of the fact that the differential above cost plus, which of course is the price in the range that tablets currently sell for, is some 27 million. And in my submission, both of those metrics are relevant in terms of the ill-gotten gain. The second point, we go to page 1709, please, is to the harm caused by the abuse during the Intas period. My lordships have the point, and we saw the NHS spending 62 million, go down a bit more please, in 2017, and it was some 40 million even in 2018. You see that in the brackets, and those are references to the Intas period. The third point is, like Allergan, Intas is a big silverback gorilla. It's a very large undertaking. And we'll see at paragraph 10.280 on page 1713, its worldwide revenue was some 1.65 billion. Profits after tax, 182 million, and its net assets were 1 billion. And the point again being made here is that when you look at the step 3 penalty for Intas of 8.9 million, it represents less than 1%. So again, we're in de minimis territory. The fourth point, paragraph 10.281, is that the undertaking had a significant proportion of its turnover outside the relevant market. Can we just scroll down, please? And you can see in footnote 3838 in yellow exactly what is meant by significant. It's an extremely high proportion of turnover outside the relevant market. Mm-hmm. And then the fifth point, which is not a new one, but it is relevant, at paragraph 10.282 is Intas specific, because here you see the CMA refer to Intas's awareness of the investigation. Indeed, it had received an SO and it had continued regardless. So again, a multifactorial assessment carried out by the CMA. Now what Intas says is that, well, abusive prices were falling. Now in my submission that doesn't qualify as mitigation. Letting an abusive high price fall from one abusive level to another is not mitigation. And you were shown yesterday the passage in the decision at page 1703, paragraph 10.247, where the CMA addressed this argument. So again, we see this is not a new argument in the CAT. It was being raised in front of the CMA. And on the hypothesis that Intas was dominant, was charging abusively high prices, in my submission, it's not mitigation to bring abusively high prices from extremely high levels to lower but nonetheless abusive levels. And indeed they are 5 times higher than competitors' prices at the end of the Intas period and pocket excess profit of 27 million above cost plus. It's just not a mitigating argument. In fact, to get some sense of the differentials during the Intas period, can we go please to page 1128 of the decision? I just want to show you table 5.24. Because again, down the bottom of the page, please. So if we go along, you'll see January 2017, July 2018. You'll see the price, £35. Cost plus, £2.17. And the differential, 1,524%. So prices may be falling, but the prices are nonetheless abusively high. And the profits are nonetheless abusively high. If I'm wrong about that, and the court does regard abusive price falls as somehow mitigating, my fallback submission would be that if you were to weigh those against the factors that the CMA took into account, there's more than an ample justification for the fine that was imposed. Intas's other argument, again, is not new. It compares its fine to the one imposed on Allergan, and we'll see it's addressed on page 1716 of the decision. At footnote 3845, it's quite a long footnote, and I'd like to just, at the bottom of the page, please, I'd like to give you the gist. And the gist is this. The CMA set the penalties for each of the addressees to be both an effective and also a proportionate deterrent. And it did that for Allergan and for Intas in light of their own individual circumstances. And in my submission, the type of cross-cutting comparison between different undertakings in different circumstances is inapt. Indeed, it's actually apt to mislead. There are differences, and we've seen some. Obviously, the undertakings are of different sizes. Intas was aware of the CMA investigation, had received an SO, Allergan hadn't. Allergan had no hydrocortisone activity at the time of the decision, but of course Intas did, because it owned and controlled Accord UK. And so we say, for the reasons we've given in paragraph 54 of our responsive written submissions, core tab 12, page 276, that this is misconceived. There is one final point which your lordships were shown and I should address, and that is on table 10.15 of the decision. and that is to be found on page 1746 of the core bundle, please. And you were shown the total penalty imposed on the various legal entities within the Accord UK Intas undertaking. And it was suggested, well, why is Intas at the top of the league? There is a straightforward answer for that, which is that the Accord UK fines for the 10 milligram abuse and for the 10 milligram agreement are subject to the statutory cap. So you're not actually comparing like with like. If one wanted to compare apples and apples, then in my submission what one would do is you would take what the CMA says about the Accord UK step-free penalty. They said they would increase it at the very least to the minimum financial benefit of some 87.65 million. For your note, that's paragraph 10.285 on page 1714. And that is 5.3% of Accord Intas's turnover, in which case it would be at the top of the league. So the only reason that the 2.7% sticks out is because the penalties that were imposed in relation to Accord UK were subject to the statutory cap. And I'm going to come on to address those arguments now, if I may. There are 7 arguments I've got to deal with for Accord UK, and I will try my utmost to deal with them as efficiently as I can. And I can do that with the first, the Department of Health's powers to regulate the price. As my Lord Justice Flaux commented yesterday, they've never been used. They haven't even been consulted on. My submission is that they are not a good reason for there being no deterrence uplift. This court, in the Latharini judgment at paragraph 230, reached, in my submission, rightly that conclusion. Authorities, tab 61, page 2089. But also in this case, the CMA reached that conclusion. Paragraph 79 to 87 of Annex F, which is at core tab 26, pages 1870 to 1872. Second point. It was referred to in submissions that the draft penalty statement the CMA had issued had originally proposed to increase the fine by 150%, whereas the decision increased it by 400%. This too is a point addressed by the CMA, paragraph 88 of Annex F to the decision, core tab 26, page 1872. And the answer is simply this. Obviously there's a time difference between when the draft statement was issued and when the decision is adopted, and the figures that were used changed in that time. And by the time of the decision, the relevant turnover was lower, so the starting point was lower, and therefore in order to obtain an effective proportionate deterrent, there had to be a larger uplift. It was just simply that the figures had changed, so the calculations had changed. There's nothing more that should be read into that. The third point is Accord UK's clarion call that it was fined way more than its statutory cap. It was not. Can I please take you to paragraph 10.151 of the decision on page 1668? You'll see here that the CMA is addressing the question of whether it should impose separate penalties for separate infringements. And I'm going to come address that in a minute. But for the present purposes, in 10.151, it's very, very important to appreciate that the statutory cap applies to each separate penalty for each infringement. And that is grounded in long-standing pre-Brexit case law cited by the CMA in footnote 3656. If we can just look at that, please. And you can see here, you see first of all, it refers to a long line of cases, and what they all say is that the statutory cap, in that case in the EU setting, applies per infringement. And in my submission, that's binding on this court pursuant to section 60 big A subsection 2 of the Competition Act, which it has a duty to ensure consistency, or at least no inconsistency, between how you interpret Part 1 of the Competition Act and corresponding questions of EU competition law. So in my submission, there is no exceeding of the statutory cap. The key question, on which of course Accord UK and the CMA disagree, is whether there's one infringement or whether there's 4 infringements. Now I come to that. What has been said on behalf of Accord UK is that there was a single course of conduct. But here again, this is an argument the CMA addressed head-on in paragraph 10.150 of the decision. But before we get there, can I perhaps briefly show the court the legal test? Because the legal test is not course of conduct. In fact, no submissions were made about the legal test for when one finds a single infringement.
Well, if you were a burglar and you went out and committed 4 burglaries in a night, it might have said that was a course of conduct, and you still committed 4 offences.
Precisely, my lord. And unfortunately, competition law is exactly where you are. And I can just show you that the judgment of this court in Balmoral Tanks, where Lord Justice Newey addressed this issue. It's Authorities, tab 42, page 1158. And it is relevant to this because if we're going to have a debate about is it one or is it several infringements, we need to know what the law is that applies. We go down, please. Paragraph 19. Thank you. It's just so the conduct can be potentially viewed as either a single continuous infringement rather than being broken down into its individual elements. And then you see a quote from Advocate General Val in the Intel case, which is an abuse case, where he explains the rationale. I'm not going to linger on that now. But what I'd like to show the court is on the next page, what the Lord Justice Newey does is set out, down a bit more please. Keep going please. Yet again, would you believe that textbook just keeps coming up? But you see the reference to the Alborg-Portland judgment. That's the cement case. Yeah. I should just correct, if I may do so, it's not the General Court that says this. This is the Court of Justice judgment. But what you see is set out the test. And the test is about that the undertaking intended to contribute by its own conduct to the common objectives pursued by all the participants. And I do emphasise common objectives and all the participants for reasons to which I'll come. And that they're aware of the actual conduct planned or put into effect, or indeed reasonably could have foreseen it and were prepared to take the risk. So that's the legal test that goes back a long way in EU case law. And if I can go back with that in mind, the legal test, to paragraph 10.153 of the decision, on page 1668. What the CMA does in that paragraph, there are a number of sub-paragraphs. 1668 of the core bundle, please.
Yeah. Yeah, that's it. 1668. Yeah.
And then go up, please. Thank you. And it goes across the page. And what I'm going to do is, there are 6 sub-paragraphs, but the way I'm going to address this court is to say that there are 3 sets of differences that informed and justified the finding made by the CMA of separate infringements. And just to identify them, first, differences between the abuses and the agreements. Second, differences between the abuses. Third, differences between the market exclusion agreements. So if I just start with the first set, the agreements, the abuses, they were exploitative in nature, started before the agreements, ended after the agreements, and did not involve Waymade or AMCO. So not all the participants. The agreements were exclusionary in nature, lasted for only 3 years, as compared to the 8 to 9 years for the 2 abuses. Now, leading counsel for Auden emphasised the interrelationship between the agreements and the abuses. And as far as that goes, the CMA doesn't in any way demur from that. Yes, the agreements bought off the competition, protected the monopoly position, and thereby allowed the price gouging to take place. But what Auden has disregarded in my submission is that there was no evidence at all that Auden activists pursued a common objective, which we saw from Balmoral Tanks, with anyone in relation to any of these 4 different infringements. And that is a point that we specifically made to the tribunal in paragraph 355 of our closing written submissions in the core supplemental bundle, tab 23, page 475. Turning secondly to the differences between the abuses,
The cement cases are slightly different in that respect, weren't they? I mean, again, there was another case I got thumped in, but there was a web of every cement company in Europe who was cartelised both within member states and across member state borders. I mean, it was a huge web of interconnected naughtiness.
Yes.
Which is classic, absolute black letter cartel behaviour of the most recondite form.
Indeed, my lord.
We're not really talking about this here.
No, and I wasn't using any analogy with cement. I was just taking the legal proposition as to the test. But you're quite right. I mean, we're miles away from an interconnected web. Because what we actually see is that all these infringements are quite discrete, which is why the CMA found 4 separate infringements. As between the abuses, the 10 and 20 milligram abuses, they differ in terms of their prices, their direct costs, their capital employed, the cost plus figures, and of course they finished at different times. And they finished at different times because entry occurred at different times. And when entry occurred at different times, there were different entrants, Waymade for 20 milligram, with different products, a full label product, as compared to Alyssa in October 2015, with a skinny label product on the 10 milligram.
There is sufficient factual differences between the various offences for the CMA properly to exercise discretion to treat them separately.
My lord has entirely got the point, and perhaps I don't need to the last one, just simply to round it off, is on the agreements. They were entered in at different times for different durations, and they had different ways of buying off the competition. Yeah. Simply just to make the point, as my Lord Justice Flaux will recall, the 10...
Lord Justice Green as well.
And I do apologise, my Lord Justice Green, both of you will recall, fondly I hope, that the 10 milligram agreement was partly the written supply agreements that were offering AMCO too good to be true terms. Yeah. You know, here's the product, a fixed volume, 90% discount. Yeah. In the 20 milligram agreement, which has not been appealed. So there, and actually that does go to a point that infringement is established by the CMA decision, and there what happened was there was a buyback mechanism. So the product never left the warehouse. Yeah. And it was just invoicing, and there was just transfers of cash to keep competitors off the market.
There are different types of keeping people out of the market, completely different ways of keeping people out of the market.
Exactly right, my lord.
So you can understand why that would be two different infringements. And in relation to the abuses generally, the 10 milligram abuse, 20 milligram abuse, you've made the point that they have different starting points.
Exactly, and endpoints as well, my lord.
I mean, in the criminal case, even where you've got 4 offences and you decide to impose penalties for each, you can make them consecutive or concurrent. At the end of the day, you always stand back and ask whether or not the global penalty is proportionate. So even if things are treated as separate, there is always a reckoning up at the end on grounds of proportionality, if you like. We call it totality, but it's proportionality.
And
yes, my lord.
That proportionality exercise here has been conducted by the CMA.
Comes in at a different stage.
Albeit at a different stage, but that then happens. Having arrived at the penalties they think are appropriate.
Yes.
They then look at it in the round and they say, well, you know, what percentage of the turnover does this represent, etc.
But both of you are exactly right, if I may say so, because of course the reckoning up does occur at the end of the CMA decision. Yeah. Just before I get to that, because I'm going to show you that very briefly. Auden and Accord, in their notice of appeal to the tribunal, in paragraph 116.1, reference supplementary bundle tab 7, page 348, told the CAT the 10 milligram and 20 milligram agreements were, in their words, separate and significantly different. So on this, actually, they agree with us that they are different as between the 2 agreements. My Lord Justice Green made the point about the criminal prosecutor and the discretion that one would have. That discretion also exists for the authority in relation to finding a single infringement. Lord Justice Newey made this point, that the idea of a single infringement is not a stick with which to beat the authority. It's meant to facilitate enforcement. And in Balmoral Tanks at paragraph 31, authorities, page 1162, my submission would be that even if I'm wrong about what I've said, and therefore even if actually there ought to be a single continuous infringement, even if there could be a single continuous infringement, the CMA nonetheless has a discretion whether or not to find one, and therefore it could reasonably exercise that discretion in this case in light of the differences I identified.
It wasn't a penalty case at all, was it, Balmoral? So it wasn't asking that question from the perspective of should the penalty be reduced to take account of the fact that these, although they're four separate infringements, there's commonality of matters between them.
Yes, the Balmoral case was different in the sense that there was a sort of main cartel with sort of three evil protagonists, and then Balmoral came to one
The decision
cartel.
itself isn't discussing this in the context of penalties.
No, that's right. No, but I'm making the submission by reference to the fact that there is this discretion. If you're against me on the question of whether there is a separate set of infringements, but at all events, what the CMA did do, as my Lords Justice Flaux and Green have identified, is that it both sought to avoid any double counting, and you see that, I'll just give you the reference, 10.155. So it would only uplift for financial benefit as between the abuses and the agreements, for example. But then it did take the proverbial step back. And you see that on page 1746, where the CMA then assessed the aggregate penalty of 112 million imposed. Can we go down the page, please? Thank you. Of 112 million. And the CMA found that this was not disproportionate in the context of four serious infringements that had reaped 138 million just on the 10 milligram abuse alone. If you'll note, that's paragraph 10.263 on page 1708. So if what ultimately matters is where you end up, and does the CMA then look at that according to metrics of the percentage of worldwide turnover and take into account the severity of the infringements and the financial benefit and the harm caused, my submission is that it did so, and it was clearly right to do so. My Lords, there are a few more points that are run by Accord UK, one of which was...
Just thinking about time.
I know, my Lord.
Now, we can stretch a bit this evening, but there will be a limit.
I have about 5 or 6 pages left, and just a handful of arguments, which I hopefully can deal with fairly
shortly. Page a minute?
My Lord?
Page a minute?
I will give it my best. I will be as crisp as I can be. The next point that Accord UK makes is that they didn't receive the financial benefit because they paid for the business. Well, there are several answers to that argument. The first of which is it's not legally relevant for the infringer to receive the benefit in order for a fine to be increased for specific deterrence, because you've seen the multiple factors that are set out in the penalty guidance. In any event, Accord UK's penalty was capped at 28.4 million, so it was nowhere near the minimum financial benefit that it received of 87.65 million. But there is an important third point on this, the question of benefit, which is the principle of economic continuity. And your Lordships haven't really been shown this, but you may have wondered, why is Accord UK being fined in relation to the period A1, the Patel phase? And can I just show you this? It's in the CMA decision at paragraph 9.74, please, page 1504 of the core bundle. I'll just take it very briefly, but just we pick it up, please, at paragraph 9.74. And this is the point that my Lord Justice Green made yesterday. Competition law has to grapple with complex changes in corporate structures, but it also needs to be effective. And there are some instances where there has to be a derogation from the principle that the offender is personally liable for the infringement. And that's where the principle of economic continuity comes into play. So we're seeking to identify the economic successor. And you see the legal test in paragraph 9.75, but let me just show you the facts and then also the important consequence. So that's over the page, please, paragraph 9.76. And the headline is that Accord UK is the economic successor of AM Pharma. And the reason for that, in essence, is because there was a transfer of AM Pharma's trading activities to Accord UK. So it was stepped into the shoes of what AM Pharma was doing. And then merrily, if we just go over the page, please, just to show you some of the things they were doing as a matter of fact. They'd contacted the customers, they bought the stock. They'd, interestingly, if we go to paragraphs E and F, you'll see that they actually had dug into the second written agreement, which was part of the 10 milligram cartel agreement. And in fact, in F, Amco, so that's the potential competitor that was bought off under the 10 milligram agreement, then actually Accord UK was then going to start paying Amco through the heavily discounted, so it's operating the cartel agreement as a matter of fact. They may say, we didn't know it was a cartel, but that's the law. What matters is what in fact they were doing. And Accord UK doesn't dispute it's the economic successor. It says that in paragraph 34 of its responsive written submissions. But the key point for my purpose is the consequence. Can we just go over to paragraph 9.85, please? There is a short reason why the CMA decided to apply this principle in this case, and it is this. AM Pharma no longer has employees, it doesn't trade anymore, and so had the CMA imposed a fine upon it, it would have been small and ineffective. And so it was appropriate, indeed necessary. You can see how small it would have been. The 10% cap would have been 1.7 million in paragraph 9.86. And so what the CMA concludes, it's at 9.90 please, is that Accord UK steps into the shoes of AM Pharma. And the reason that's so important is that when the CMA then sets the penalty, and it's doing so in relation to the Patel phase, period A1, it's entitled to take into account the minimum financial benefit of £77.5 million that were reaped for 7 years. That is what effective application of competition law requires in my submission. It was an appropriate thing for the CMA to do. We are literally in the home stretch. I have 2 arguments and then I will stop. The 6th argument was Auden and Accord's challenge to the tribunal's failure to quash the penalty for the 10 milligram agreement. This, as my Lord Justice Flaux may recall, and Lord Justice Green, focuses on paragraph 137 of the judgment in the cartel case, H2. Before we look at that infamous paragraph, and I'm, in light of yesterday's discussion, not going to address you on application for permission to appeal, I'm just going to focus on the substance. Can we just pull up the tribunal's explanation of the relevant law and then see what it held? So can we go please to the core bundle, tab 17 at page 580. And what we see, if we pick it up and go down please to paragraph 95, an approach to attribution, and the tribunal kicks off with the incontrovertible description of an undertaking as a unit of account. It is explained here that, that legally recognised entities, natural persons, legal persons, etc., form part of the same economic unit. Their conduct, knowledge and state of mind can be pooled and collectively attributed to the undertaking. If you just go down the page, please, the court can see. Thank you very much. You can see what I was just describing. You then see this is not new law. Mr. Justice Barling considered this issue in a cartel damages claim in paragraph 96. I'm not going to linger on that now. So that is the sort of the law as it was set out by the tribunal in H2, but it wasn't out on a limb. It had High Court authority that had made a similar point. And then if we go to the relevant part of H2, which is paragraph 136. Thank you. So, it's in this judgment, it's tab 17, and yes, I'm very grateful. So at 136, this is where there's a lead up, first of all, and it's important because you weren't shown this. In 136, the tribunal says, we consider, for the reasons they've given earlier, I've shown you those, where one undertaking knows of an unlawful agreement like the 10 milligram agreement, and that undertaking is acquired by another company in circumstances where the acquiring company becomes a part of the same undertaking, then the guilty knowledge of that undertaking infects the rest provided the test for defining undertaking is satisfied. Now, what you were shown yesterday was the finding that's made in 137 that the various acquirers, as my Lord Justice Zacaroli pointed out, the acquirers didn't know or should have known of the illegal aspects of the 10 milligram agreement. Now, as my Lord Justice Flaux pointed out, by reference to paragraph 117 of the judgment in Ping, you don't need to know the illegal aspects for the undertaking to have intention, ignorance of the law, mistake of the law is irrelevant. So, in a way, this finding doesn't help the appellants in the way that they contend, and certainly doesn't mean that the tribunal failed to quash the penalty on that basis. But there is more, because what you were not shown yesterday, but over the page, in the same paragraph, is the answer, consistent with what I showed you earlier on undertaking, is the tribunal say, we do not consider that these conclusions, the ones they've reached earlier in the paragraph, are relevant to the question of the intentional infringement of the 10 milligram agreement. Why? Because the acts and state of mind of Auden, so Auden here is referring to AM Pharma, because Auden was part of the same undertaking, are the acts and state of mind of these entities also. If Auden was infringing, then so are they. My submission is that's true of AM Pharma, and it's also true later on of Accord UK. The infringing subsidiary knew all the essential facts it needed to know, and therefore that's enough for the undertaking to commit the infringement intentionally. And that last sentence in my submission puts it very nicely and correctly. The final argument, my lordships will be delighted to hear, is the failure by the tribunal to take into account its own market definition. We're now going back to the dominance judgment. Your lordships will recall that the tribunal disagrees with the CMA in the respect of including clenodrin and in the respect of saying it's just one market kind of throughout. But it's important not to overstate the differences. I mean, the CMA found for the first 7 years, out of an 8 to 9 year abuse, there was one market, 10 and 20 milligram agreement. The only difference between what the tribunal found and what the CMA decided was that the CMA said that competition played out differently after entry occurred for the different strengths. Now, if Auden and Accord are saying the tribunal should have imposed a single fine in light of the market definition, well, you have my submission. There are profound and sufficient differences between the infringements that mean that's not correct, and the single market definition does not in any way determine that outcome. If, on the other hand, Accord and Auden are saying the tribunal should have recalculated the penalties for separate infringements using the turnover from the tribunal's relevant market, well, that, of course, hurtles into a problem of a double counting issue, because essentially you'd be using the same relevant turnover from the same single market for two separate infringements. But of course the CMA avoided that double counting issue, because even though the CMA defined one market, 10 and 20 in the same market for 7 years, when it came to calculate the relevant turnover for each separate infringement, it used the 10 milligram turnover for the 10 milligram abuse, 20 milligram turnover for the 20 milligram abuse, and it did that to avoid double counting. My final point on this is that the relevant market is used to calculate relevant turnover. As my Lord Justice Green observed, that's for the starting point, it's not the finishing point. So even if the tribunal's market definition had in some way implied that the relevant turnover should be different in some way, in my submission, when it came to the adjustments at step 4, looking at specific deterrence proportionality, what matters is the overall fine that's imposed. And in conclusion, in my submission, the tribunal was right to find in 375 that the case involves extremely serious and extremely harmful infringements. The CMA made that finding as well in paragraph 10.129 of the decision. The winners, financially speaking, are the infringers. They reap profits of £270 million above cost plus, or £100 million above the £20 enforcement price per pack. The loser is the NHS and patients. They're the ones that foot the bill. They're the ones that have to pay up to 84 million in 2016, 62 million in 2017. So we say that the fines were set by the CMA and they were properly upheld by the tribunal to reflect the seriousness of what happened. And the reason for that is that there needed to be a clear warning, as my Lord Justice Flaux remarked, But anyone else that may be tempted to share markets or indulge in excessive pricing should think twice by reason of the substantial penalties. And unless I can assist the court any further, those are the... I apologise. So I'm grateful to those behind me. On the question that I had of the court in relation to specific deterrence, in the core bundle, page 1869, in an F of the CMA decision, at paragraph 78, there is some discussion there of specific deterrence and to what it applies.
Did you say paragraph 98 or 78?
It's 78, my lord.
78.
Is it good on the next page?
Yeah.
Is it?
Yeah.
Yeah.
Yes, you can just see there's a description there of
Yeah.
of the need for
Yeah.
deterrence.
The fact that they no longer own the direct infringing entity.
So unless I can assist your lordships
It's not yeah.
further, those are the submissions of the CMA.
Thank you very much indeed.
My Lord, may I just start by inquiring as to the ultimate time limit today? We'll share our time accordingly, cut our cloth.
Sorry. Quarter to five, the latest.
Thank you. Right, well, that gives us an hour at the most, so we'll divide our time. Thank you. My Lord, I'm going to start with dominance, then move briefly to abuse, and then on penalty.
Just say, if there's going to be further document, if there comes a point where there's a point or an issue which you want to send us a page or two later on, then we can consider that at the end. So I don't want anyone to feel they're short-changed in relation to something they just don't have time to address.
I'm very grateful.
We'll do a catch-up at the
I'll
end.
see how I get on. Mr. Armitage submitted at the outset of his submissions that the assured customer base point was not one of the legs of the stool upon which the decision depended. It was just the reason why Accord UK could maintain a price premium, and what mattered was that premium. It didn't ultimately matter why they could maintain that premium. He said it was just that, as a responsible regulator, the CMA wanted to understand why it was Accord had been able to do that. Well, of course, it mattered why, and it was a leg of the stool, as the repeated references to the point that I showed you on Tuesday in the decision demonstrated. The question was whether Accord's price was higher than skinny competitors because it had market power, which it was exploiting, or whether pharmacies and wholesalers were exercising a free commercial choice in respect of a differentiated product which was offered to market at a premium price, but which they were free to accept or reject. If they were exercising a commercial choice which depended at least in part on a perceived regulatory risk in any one case, which did not in fact exist, then there could be nothing assured about their custom for Accord UK over time. That incorrect perception was vulnerable to change at any time as dispensing of skinny labels became widespread and the views of the NHS Chief Pharmaceutical Officer and tendering practice and the views of the MHRA became known. Accord couldn't price on the assumption that these customers were captive. And that's the point I made to you, I hope, on Tuesday, but that point about that lack of assurance, that potential for change, and nothing being immutable, was entirely omitted in his submissions by Mr. Armitage. Hence, we said, there was a need for the tribunal to look at the disclosure, that is, the internal documents provided by the various pharmacists, those who did switch, those who did to some degree, those who hardly did at all, to see what their reasons were for their choices and the extent to which price mattered to them. The really important point Mr. Armitage told you this morning is what the pharmacies perceived. That's how he put it. Well, that's what these documents showed. Were they captive because they thought of themselves as having no choice, as the CMA had alleged? Or were they in fact exercising a choice on the basis of their own preferences, balancing other matters? And regardless how fixed or immutable were those preferences and perceptions of risk. Now, that was a hugely contentious factual issue. It was one upon which it would have been open to the tribunal to make a factual finding. Mr. Armitage spent a lot of time seeking to persuade you that it did. I don't accept that, but go with it for a moment. If it did make such a factual finding, it was required to make that finding upon consideration of the evidence. It came nowhere close to doing so. This is not Henderson or Volpe territory, as Mr. Armitage briefly tried to submit, tucked it in at the end. This is not a question of a single piece or pieces of evidence not being expressly mentioned in the judgment, and that in itself not being sufficient to lead to an inference that it was overlooked. This is South Bucks and Porter territory, CR Skeleton paragraph 14. It's a principal, important, controversial issue which simply isn't addressed, say that Mr. Armitage's high point tucked away in the market definition section, the endless sub-paragraphs that we considered and found at the end, dealing with the question of what price the hypothetical customer should be assumed to be purchasing the product. Further, it's sprint room territory, failure to take into account some material factor which undermines the cogency of the conclusion. So Authorities Bundle 1196 and CR Supplemental Skeleton at paragraphs 11 to 12. Mr. Armitage showed you some of the evidence in the decision on specific customers, focusing on boots in particular, randomly alighted as it happens on his best available example. He didn't show you our response to that, or indeed any of the other evidence. Now, this is not the occasion for going back into it in any detail, but I did make a request for the court to read certain pages, and I'm going to reiterate that now with a bit more force. The underlying documents were analysed extensively in our written closings, not just the 100-page annex, but in the substance of our closing. And it's included reference supplemental bundle 17, page 1302 through to 1326, paragraphs 53 to 86, with particular emphasis on paragraph 66 onwards, please. I'm going to invite the court to read that in more detail, not because I'm asking you to accept, obviously, what we said, but to understand the scope and extent of the factual issue. And I'm just going to light now, I ask you to read it all in context, but we can go to page 1310 of the reference supplementary bundle. This isn't the full extent of it, but and scroll down, please, to where it says ASDA. There we are. So there's a section going through all of the pharmacists, reviewing what the evidence actually was about whether they were captive, to what extent they perceived a risk. ASDA had told the CMA that Teva was its preferred supplier, but it just went with whatever the wholesalers produced to it. It won't take a long time over this, I haven't got it. Over the page 1311, Sainsbury's had been identified as a supposedly assured customer, but it had exited the market in September 2016, before the start of the Intas period. Further down that page, Morrison's, identified as a supposedly an assured customer, but it switched to skinny label products in 2016, later switched back from April 2017, so that's mid-Intas period. And discussion of why that was, and various pictures that Alliance, through the parent, the upstream branch of Boots, Alliance wholesaler, had sought to sell its own branded Alma's product. There was rafts of evidence about this. On the next page, Superdrug suggested it generally made limited purchases, according to CMA in its table, but when you looked at the data unpacked from June to September 2016, we could see it made a big switch to skinny and then switch back. So these suppliers with supposedly immutable preferences, captive and assured, either didn't care or weren't active in the market or were in fact switching. Down the page, Lloyd's, one of the two big ones. The evidence was based on their initial decision whether to stock skinny label products, which they made as early as December 2015, was based on a balance between the potential profits from switching to skinny labels and the hassle that switching was entail, but it was explicitly acknowledged that this may change if the price differential grows, i.e. the gap between the price of full and skinny. One of the very factors which of course is pulling our prices down as skinny prices reduce. And others were at the other extreme. Well made virtually no purchases of the skinny label tablets, scrolling down the screen, but there was evidence as to why that was. Again, I won't take time over it now. And then on the next page, you had the hardliners, which were Boots and then Roland. But Boots, again, didn't. What it showed is that they made a decision in January 2016. At that point, understandably, that early, on the basis of a misconception over regulatory risk. The passage that Mr. Armitage read out to you mentioned product safety as a consideration, which we know doesn't apply in this particular context. But then didn't re-review it at any point afterwards. He said, well, there was a later document in 2021. But what they said is, we never reviewed it again. That decision was made then and we just never came back to it. Well, that's the extreme worst case for us. That and Roland, who just said we're not having anything to do with it. But between them, they're less than 20% of the market. Now look, the short point for today is this was a factual dispute as to whether or not this customer base was assured. And what we said was that the passage in the decision which set out a summary of why it was that this was said to be an assured group of 8 customers was selective, not exhaustive. There were many, many more documents disclosed to the CMA which they hadn't referred to, and which we did. Now, to say that that the tribunal considered all that and reached a conclusion tucked away in the manner it did in the market definition section is wholly inadequate as a resolution of our case on that. And in the dominant section, there's no separate consideration of it, but my learned friend alighted on the words that in paragraph... sorry, I'm in the wrong bundle, so I can't see that. Alighted in the words, we have described the nature of that disadvantage already. And he spent a long time taking you through all the evidence, including the evidence of Dr. Newton, as to how the regulatory risk perception had arisen and all that. None of it was in dispute. Indeed, Mr. Burt's evidence that he took you to, a paragraph of that recognising always that some pharmacists recognised a risk, not recognising, as Mr. Holmes tried to suggest to you this morning, that therefore there was an assured customer base. That is not what he said. So there is real dispute over this, and it's now advanced to my lords that there was a factual finding on that issue, which I can't reach the threshold for disturbing. But my principal case remains that is not, in fact, when you look at the decision, a factual finding on this issue. It falls short of finding there's an assured customer base, and it falls short by some distance.
So your points are, one, that they didn't so find properly read, fairly read. Two, if they did so on inadequate evidence.
It is wholly inadequate.
And you've given us the list of evidence which we can then compare and contrast to see whether or not there's a fair assessment of your evidence.
The list that you asked for...
No.
Yes, that's for my closing submissions.
Yes.
It refers also to the annex, which is tucked behind those submissions.
Yes.
You'll find it. I'm not, again, feel the width almost rather than spend time over the detail. But it was a substantial and important principal controversial issue, and you will not find any reasoned decision on it anywhere. And it goes, of course, to the strength of market power. Because my learned friend says, well, what really matters here is the pharmacist's perception. But yes, up to a point, yes, that's what's governing their purchasing decisions, but it goes beyond that, which is why you need to look at all that evidence, the tribunal should have done.
Yep.
But it also goes beyond that, because we don't know how at any one point their minds are working.
Yep.
We don't know how close they are to switching. That's precisely why we don't have control over our prices dropping, why we're continually forced down. And that is directly relevant to the question of whether or not we actually have market power to an appreciable extent. Now, I've never suggested that they need to show we have absolute power. Of course I accept the appreciable extent test.
Yeah, we understand.
But of course, this was precisely the point that we just didn't know how close anyone was to switching at any point. We didn't know when word would get out or become accepted within any one pharmacy that actually MHRA completely happy about it. Clearly that they were. Again, I didn't take you time. I gave you the references, where all of that is set out and accepted by the CMA as well as by the tribunal. Now, where does all that take us? As I say, it feeds in because what Mr. Armitage submits to you is well, that's all just background to the fact that there was a premium price. And we say yes, there was a premium price because there was a differentiated product, and we did have a gap between our price and the skinny price. That much is obvious. But why is it that we could maintain it? Was it through an exercise of market power, or was it because there were preferences being expressed by these individual purchasers who were putting weight on such things as the amount of hassle to switch, for example, and other factors, price then coming into the equation and the balance being struck? That is a normal part of a competitive market. And it would have been open to the tribunal to analyse through all of that and reject our case if it didn't accept our reading of the documents or whatever it was. But none of that is present.
Yep.
And note that my own friend didn't offer an explanation of how it was that the tribunal could have reached the conclusion that it did on market definition if it was also concluding at the same time that all our customers were assured. You'll remember the tribunal dismissed arguments by Advance and Sinven saying that full label products were in a different market because they had an assured customer base. They said the CMA is trying to ride two horses at once by saying both that there's an assured customer base on one side of the market, but also that there's a single market. And that's why there were two other experts called by Advance and Sinven saying that there was an assured customer base. But the tribunal rejected those appeals. It said, no, skinny label products are in the same market and they are in competition with full label products. We ask, how could it have reached that conclusion if it was upholding the CMA's finding that there was an assured customer base? And where is the explanation for that? Because just as Advance and Sinven were making the submission on one hand, we were making the submission on the other hand, which is within the passage I've asked you to read, saying the existence of an insured customer base is inconsistent with the single market.
Yes.
That's nowhere resolved.
No.
You will be well aware, and no doubt have anticipated my submission on the curious, indeed I'd say baffling, submission by my own friend Mr. Armitage, that you could somehow tot up the number of expert economists and take that into account and what their different views were. All of this was a factual matter for the tribunal to determine on the documentary evidence. This wasn't a matter for expert economists to opine on. Of course they referred to these matters because it was relevant then to their assessment of the extent of market power and dominance. It's relevant factual background. But whether or not there was an assured customer base was obviously a matter of fact for the tribunal, not for them to choose which expert opinion from an economist they preferred. And that is not the appropriate basis upon which to have approached it. So Mr. Armitage described how this supposed assured customer base reacted. He said a group of customers who voted with their feet. Exactly right, we say they were making a commercial choice and they were free to switch. They did so because they valued our product. and just to deal finally with the point about does it actually appear, the high point of my learned friends, reference in the judgment is to page 411 of the core bundle. And what you get there is not any reference to an assured customer base, but an acknowledgement that some pharmacies regarded fully label and skinny as substitutes, others regarded skinny label as different and non-substitutable products. Well, that would be essentially true of Roland, and to an extent that they thought about it, Boots. But we had a whole suite of arguments about other pharmacies and indeed the wholesalers, which we say just cannot be taken to have been resolved there. And it's notable that the tribunal avoided the language of an assured customer base or no choice or anything of the kind.
Yeah.
My lords, turning to market share, you'll need to treat the evidence in the decision that Mr. Armitage showed you with some caution. You'll remember the two graphs that he showed you with the coloured rainbow at the top, one for value and one for volume. You need to treat that with caution because it doesn't reflect the tribunal's conclusions. It reflects the CMA's original decision. The tribunal's conclusions were on the basis of a revised market definition, which included Plenadrin. And that makes a difference on value in particular, and almost 10% in fact. And of course on volume...
You want to give us a paragraph number and the revised figures?
The revised figures for paragraph 289 of the judgment, so far as the Intas period is concerned, that's core bundle page 439. And we can just pull up, I think it's 439, I think then we'll want 440. Yeah, that's where it is, and 440.
So what are the two different market share figures?
Well, if we go to 440, please, at the bottom of the page, you've seen this before.
Yeah.
That was the average over the Intas period, which were 40.5% on volume against 63 on value.
Yeah.
And you have my submission for that, but what Mr. Armitage did is he put before you the CMA's decision document, asked you to eyeball it, and say you can see it's around 50%, doesn't really go below 50%. Well, that is not a satisfactory way to approach this, and the tribunal has calculated the actual numbers, and the average over the period is 40.5%. Yes, as I've always accepted, the value is higher, but that, for the reason that Lord Justice Zacaroli alighted on, is less helpful than it might be in a differentiated market where you've got different pack sizes and so forth, and you're trying to account for those differences. What it's doing here is simply reflecting that on one side of the market you've got a premium product, a differentiated product, and that isn't enough to tell you that there is dominance. So Mr. Armitage, therefore, painstakingly went through the decision's findings about our prices. But of course, he had to concede at the end, when he got to the judgment and the tribunal's assessment of dominance, that the tribunal rightly concluded that it couldn't actually put much weight on the prices as evidence of dominance, because that would lead to a bootstraps approach. It's precisely just recognising that there is that differentiated market and that premium isn't probative of dominance. So where you are, or where we were forced to reduce the price inexorably, it remains the case that you're not able to act independently to an appreciable extent, and the reverse is not shown simply by pointing to the fact that it's a differentiated market and you're charging a higher price. The premium over others exists even when at base, you were shown table 5.3, reflects economic value. Economic value can change over time as customers' preferences change. That's something Mr. Burt pointed out in his witness statement. But here, we say even if in 2015 there was genuine uncertainty around the risks of dispensing skinny label, by 2017, when a significant part of the market was doing this, indeed widespread, as the CMA said, that uncertainty must have diminished and must have continued to diminish. Mr. Armitage put little emphasis, indeed, he didn't even refer to the tribunal's findings of fact that prices were falling as a result of competition, and that the CMA's expert had accepted that Accord was unable to resist the falls. The submissions that you heard on dominance, we say, failed to meet the mark. the tribunal's judgment was inadequate at the very least, and even if this court can't be persuaded on the basis of what you've seen that we deserve to succeed on our complaint that we were not dominant, the matter would have to be remitted to be dealt with again, to be actually considered on a proper and full basis. So far as abuse is concerned, there's the argument about impose. My own friend said he had a factual answer to that, which was the assured customer base. That falls away, if I'm right in what I've said about that under the dominance heading. He also said that there's a legal answer, but that was misplaced. It is obviously a word in the legislation. It has to be given some meaning. It cannot be ignored. The word impose must reflect an exercise of market power. It has no meaning in circumstances where customers are free to switch away. If you're simply offering a price to the market and everyone reacts by saying, well, that's a bit high, no thank you, I'll go to one of your competitors, then you're not imposing a price on anyone. There must be a degree to which you can impose a price.
Except the word appreciable.
Yeah, appreciable. Yeah.
I mean, I don't think there's any dispute between you actually that if this is not, if the pricing wasn't connected to an appreciable exercise of market power, then that's the end of it.
Yeah.
If it was, then there's a prima facie case of abuse. It's the exploitation of that market power, but there's got to be the causal link.
Yes, and there must be an appreciable market power to, which allows you to exercise
a power over price.
But that doesn't prevent there being other competitors in the market. No, clearly not.
That's a different point.
Exactly.
Appreciable market power is sufficient, if all other things being equal, to show that what the price is being imposed.
Yeah. Exactly right. But Mr. Armitage was suggesting, he took you to United Brands and the familiar thing, the test of fairness may depend in part upon comparison with competitors' prices. Absolutely right. He said, well, that's inconsistent with my reading of the word impose. It's absolutely not, because market power, to an appreciable extent, can be exercised in a number of ways. Yep. In United Brands, it was being exercised because of restrictive terms in the United Brands trading agreements, which had partitioned the relevant market, riding on the fact that bananas get ripe. And, that was the vehicle.
The green banana clause.
Yeah, exactly. There it is. So we say that that argument is good. I'm going to skip straight to penalty in the last 5 minutes or so that I have. But if I'm wrong about all of that on dominance and abuse, everything that I've said so far still feeds in, or should have fed in, to the appropriate penalty. There is a vast difference between the conduct of an undertaking which exploits a monopoly position to raise prices from the starting point you've seen up to £72 a pack, and one which is skiing downhill the other side of the mountain, allowing, indeed being forced to drop prices rapidly over a comparatively short period of time in response to competition, and believing, even if mistakenly, and even if this doesn't negate intention for the purposes of jurisdiction to impose a penalty, believing that they were facing competition and that they were responding to the competition, that they were no longer dominant and that they were certainly not abusing. That's not a defence to the tort, if you like, but it's a relevant factor in mitigation. And it is a serious difference in culpability between someone who is riding that downward slope as opposed to someone who's exploiting power in the first place in the absence of competition, indeed entering into agreements to keep competition from coming in, all of which was taken into account as feeding the seriousness, the highest level of seriousness in respect to the undertaking as a whole, but none of which applies in Intas's case. And the fundamental point that we made to the tribunal, which isn't addressed anywhere.
You ended up with the biggest fine.
It wasn't the biggest fine, it was 44 million. Allergan's was bigger, but in comparative terms, they were 0.3% of their, we were 10 times that, just under 3%.
We've got that.
And I know you've got that point, I'm not going to labour it. But none of that is taken into account. And my own friend Mr. Bailey just sought to caricature that by saying, oh, well, you're just replacing one abusive price with another abusive price, and somehow that's that is a caricature of the argument. It evades any of the subtlety of the position that Intas found itself in post-acquisition. Its ability to read the market, to understand what the position. Yes, of course, it knew what profit it was making. All the rest of it, I'm not suggesting. No part of my submission that it didn't. So Mr. Bailey did submit to my lords in the case of Allergan that stage one, the stage one starting point, didn't reflect the scale of the infringement during the period of Allergan's ownership, because actual selling prices reached their zenith during that period. So that adjustment had to be made up from that because of that. But the exact reverse point applies to us. We're not at the zenith. We're managing, indeed dropping our prices in order to try to retain market share. And the point that Mr. Armitage made still comes back and is relevant in this penalty section. Yes, 40% is still significant to retain on average over the Intas period, but that was retained only because you were dropping the prices. You saw the way the graph went, it went down even lower to around 30%, then it did go back up again over that period of time, rapidly dropping prices, trying to keep that. So all of that had to be viewed and understood. My lords, the point that you've made, I'll call it the bandwagon point, we'd hope to claim some credit for setting the bandwagon rolling in our grounds of appeal and indeed curtain argument, because it is precisely our point that the tribunal didn't deal with these points.
But once we see the schedule, we'll have a much better idea.
You will.
And then we'll be, once we see it, we may want to come back to you, or we may not. We may actually feel we can understand the nature of the arguments you all want to make and the arguments you made in your only submissions. And that may be enough.
I very much hope it is, and certainly my submission, it should be. The overriding submission I make, apart from the detail of that schedule, is that what you get in those two paragraphs, 375 to 376 of the judgment, is a wholly inadequate discharge of the judicial function as regards Intas's complaint. Yeah. You can't even tell what our complaint was, let alone why it was dismissed. And my clients were left simply not understanding what had happened to their appeal, or why they're held responsible in equal measure in terms of seriousness for conduct going back to 2008, or why there's therefore a need for specific deterrence in their case on that scale. I'll just take a moment. I'm just reminded of one other point. Can I ask you to read Mr. Burt's witness statement, just in response to the point that, well, Intas were warned about all this.
Why don't you give us the reference and
yes,
tell us what the
I'm
point is?
I'm just going to give you the reference is in the core supplementary bundle, tab 16. Mr. Burt is at page 194, and the relevant paragraphs are 41, please, on page 206 through to 47. And it's the care with which Intas engaged with the CMA. You might have been left with the impression that simply ignored it and waited to say to play, but they engaged, they had discussions, they formed their view in the light of it. They were told that there were no final decisions yet from the CMA. They believed that market conditions had changed since they had existed pre-Intas period, and they took a view on that point. There wasn't any sort of callous disregard of the kind that was being suggested.
Okay.
I'm very grateful.
Thank you very much.
My lords, on excessive and unfair pricing, we say there are essentially two questions. Firstly, did the tribunal apply the wrong test? And secondly, did it make any difference? On the first point, did it apply the wrong test? Mr. Holmes' submission was that the tribunal's three-case taxonomy was essentially benign economic musings, and that at best it could be criticised for not taking the test much further. We say that on a fair reading of the tribunal's judgment, that was absolutely not the case. The court has my fairly lengthy submissions overall, and we'll have to essentially read the judgment and take a view as to its construction. But I do make 2 points. If we could please turn up paragraph 342 in Core Bundle 16, page 461. Page 461, please. Paragraph 342 is the precise paragraph where the tribunal is specifically considering the prices in this case. And if we look at the end of subparagraph 1, we see the final sentence. In our judgment, therefore, If the case is a case 3 case and not a case 2 case, these prices are abusive because they cannot be justified.
This is the bit you referred to us in your opening, wasn't it?
It is indeed. To be fair, we've looked at it already. Lest it be suggested that the reference to no competitive reason can be articulated permits a consideration outside the tribunal's 3-case taxonomy, we can look at footnote 434. And there we have a reference back to case 3 and case 2 and case 1. So the simple point we make is that there is no space in this approach to permit the sort of open-textured, non-prescriptive analysis of the other factors that are referred to by this court in Flynn Pharma. The second point I make is concerned with paragraph 339 at page 460. And this is the paragraph in which we had understood there was a relevant dispute about the construction of what the tribunal was saying. In particular, the reference to any and whether it doesn't permit any excess of price over costs. Mr. Holmes has fairly said he saw the force of our submission, that this is dismissing patient benefit as giving value over cost at all. If we look, please, at the CMA's skeleton at paragraph 44, so core bundle 172, this is the paragraph that took issue with the construction, but note the second line, for the avoidance of doubt, the CMA agrees that such a rigid approach would not be correct in law. So insofar as it is conceded that that's what the tribunal's saying, there appears to be a concession that that is not right in law.
Yes.
So we say, and the answer to question 1 is the tribunal has clearly applied the wrong test, and we then move on to, well, what difference does it make? In that respect, you're being offered some beguilingly simple ways through. You're being told, for example, just look at the pricing where it's settled post entry by the generics, and you're being told look at the prices that were initially applied by Mr. Patel when he initially acquired the marketing authorisation. The simple point we make is that the legal test doesn't say look at where the market settles post entry. Anything above that is abusive. And the legal test doesn't say look at the lowest price that this undertaking was prepared to sell this product at. Anything above that is abusive. At most, we say this reliance on the before-after pricing is one potential comparator. But we know from phenytoin, paragraph 199, the importance of cross-checking. And we have offered alternative comparators, and there is a duty on the tribunal and the CMA to address them. Now, it was said in that respect on behalf of the CMA, and it was such a good submission that it was said twice, once by Mr. Holmes and once by Professor Bailey, that as regards whether you need
they were that nervous, they had to do it twice.
That may be the explanation. But it goes to the key point that this court has been trying to explore, which is, well, do you need to get into regressing the prices of, for example, Plendron or Hydrocortisone to try and establish what that comparator would show you in, if their case is accepted, a market which is in fact competitive. That's obviously not accepted by us. But the answer was, no, you don't get into that because the best comparator is the before-after pricing comparator. So there's no need to engage in that very tedious exercise. But in our submission, what's going on there is that the CMA is using its preferred comparator as a reason not to engage in a proper analysis of the alternative comparators that are being put forward by the appellants. And that, we say, is essentially a breach of the duty properly to consider alternative comparator evidence. This before-after comparator was also advanced as an answer to all necessary inquiries about economic value. It was said you don't need to get into that because look at the prices afterwards. And on patient benefit in particular, the submission was made that there are many useful generic drugs which are supplied for pennies. Now that might be true, but that doesn't answer the question whether patient benefit for those products would permit a higher price lawfully to be charged. And that's absolutely why we need to get into questions of comparators, including questions of comparators of different products that aren't simply the same product after entry. On the question of Auden being the reason that this drug was on the market at all, it was conceded that that is not addressed in terms by the tribunal, so we don't know what it might have said about it. But in our submission, that is a good example of a factor which ought to be capable of being factored in on a broad assessment of fairness, but does not fit into the tribunal's 3-case taxonomy. On the value of the full label indication and the fact that Auden was able to supply a full label product, Mr. Armitage spent a good half a day explaining the extent to which this is valued by some of the pharmacies, so much so in his submission that they left money on the table in respect of it. We say that is all evidence of economic value accorded to Auden's product, which ought to be taken into account in the assessment of excessive pricing. The answer that's given to that submission is to say, oh well, it's just a regulatory quirk. And this is not legitimate economic value. And look at what the tribunal said about this being a product of a misbegotten regulatory regime. Now, ordinarily, when one is assessing the market, one would take into account the effect of the regulatory regime as part of the background and part of the way in which that market works. And so, if the regime causes certain characteristics of products to be valued, for example, because those characteristics mean the products are compliant with the regulatory regime rather than non-compliant with it, then one would expect that to be something which is taken into account in assessment of the market. Now, what's being said in this case, slightly oddly, is that for some reason the regulatory situation in this case must be disregarded. It's not permissible to take into account the effect it had on demand in the market. Now, in our submission, that is an unsustainable position. The orphan drugs regime is not challenged as unlawful or impermissible, and it's a surprising proposition that it should therefore be disregarded. Its effects on demand in this market should be completely disregarded on the basis that the tribunal has taken the view that it is a misbegotten regime. Now, in our submission, the correct approach to economic value is a factual inquiry. It should ask, factually, what do the purchasers in this market actually value? In our submission, the tribunal goes wrong if it is not asking what do they in fact value, but what should they value. It shouldn't be engaging in some sort of normative inquiry about whether the regulation which causes these effects is or is not well founded. On comparators, Professor Bailey addressed you on Plenadrin, and he identified broadly two bases for distinction. The first were clinical and therapeutic qualities, and he referred back to findings in the decision on those points. But of course, we know that in the judgment, the tribunal has found, first of all, that Plenadrin is substitutable for hydrocortisone tablets, and it found that there's no support in the decision for any relevant clinical distinction. So in our submission, insofar as it's being suggested that it's not a good comparator on those grounds, that has been superseded by the judgment. He also made reference to the fact that it's a product which is used by a minimal number of patients. We know why that's the case. It's because it's too expensive. And we maintain that there is a massive illogicality in disregarding a product in the context of an unfair pricing case when we are being accused of charging too much, disregarding a product because it was too expensive. In respect of hydrocortisone, Professor Bailey took you back to the passages in the judgment where that was discussed as a question of fact or market definition, but he did fairly accept when my Lord Justice Green put it to him that those passages were not dispositive of an inquiry about whether hydrocortisone is or is not a valid comparator. We say there's no getting around the point that the tribunal hasn't properly dealt with it in that context. For completeness, if we turn up what it did say at paragraph 348 on page 463, there was a reference to the fact that this paragraph refers to a number of products, and so as I understood the point that was being made, it was seeking to infer that hydrocortisone was covered within this paragraph. This
which is rather undermined by the word notably, which follows.
Well, it's partly undermined by that, but it's further undermined by the fact that this is...
It's a bit thin, we get that point.
It's also, it's referring to products in the market, medicinal products in the market. The tribunal has found that hydrocortisone is not in the market, so it can't be covering it in this paragraph.
Yeah.
That's the short point. For both of those products, the CMA has taken the point. They say these are not comparable prices because of the question about whether or not they are actually competitive prices or not. In the context of the burden of proof debate, Mr. Holmes quite fairly conceded that the instance of the evidentiary burden goes by the party best placed to address it. Having conceded that, in my submission, the question of the pricing of Plenodrine and whether it is or is not competitive is something best addressed by the CMA, and the question of the pricing of Hydrocortisone and whether it is or is not competitive is something best addressed by the CMA. Did the CMA actually do that work? No, it didn't. And the reason, as we've heard in submissions today, is because they took the view that the best comparator was the before-after pricing. And so on that basis, they did not investigate further. And we say that that is a breach of the duty fairly to consider comparators. I'm moving on to deal briefly with penalties, and then I'll hand over to those behind me. On the question of whether the tribunal has done a proper job, the high point of Professor Bailey's submissions was his reference to paragraph 374, subparagraph 2, which is page 471 in this bundle, please. And he referred to the fact that the tribunal says we have, of course, taken into account the submissions made by the appellants, taken full account of the submissions made by the appellants. It's important then to read the next line. We've not set them out in any detail because our starting point is the CMA's approach and whether that approach is or is not defensible. This is simply another paragraph where it is exhibiting the wrong test. Asking whether it is or is not defensible is not the right test in our submission. This is not an Article 6 compliant review of penalties. My Lord Justice Green posed the question, is it enough to say we endorse the CMA? In our submission, it's very clearly not. And my Lord Justice Flaux made the point that it seems as though the tribunal's treatment of penalties is something of an afterthought. We agree with that perception, and we would add that we had to remind the tribunal that it was necessary to deal with the 20 milligram penalty because it hadn't done so in any of its previous judgments, and that's what then prompted H4, which addressed that particular point. Professor Bailey made a submission, well, what if we went through and addressed each argument? What difference would it make? Well, the difference from our perspective is that we would have full reasons as to why those arguments were rejected, and we would then be in a position to appeal them. We are hindered in our appeal before this court by only having 2 paragraphs that we can address in terms of the reasoning. And the submission was made...
Like I said, that's all the more important when this court has full jurisdiction over the merits.
My Lord, yes. And the CMA is asking you to exercise it in circumstances where we simply... the submission was made that you've had 2 full bites of the cherry. We have not, because we do not have the reasoning that we need to be able to actually exercise that bite of the cherry in this court. Specific deterrence is a classic example of something that was not addressed in the decision. You were shown paragraph 2.21 of the penalty guidance, which tells us that specific deterrence, amongst other things, ensures that the penalty imposed on the undertaking will deter it from breaking competition law in the future. Our submissions on this point went to exactly that question. Is there any reason to think that Actavis, which is being fined as an economic successor, is going to have a propensity to infringe to such a degree that its penalty needs to be uplifted from what's obtained at the end of stage 3 in order to prevent it from doing so? And in my submission, nothing that was said this afternoon actually gave any reason to think that that was in any way likely or necessary. There was also submissions on financial benefit and the suggestion that the financial benefit must exceed the ill-gotten gains, as it was put. What the CMA, in my submission, haven't grappled with is our point that financial benefit doesn't work in relation to a subsequent purchaser of an infringing entity, because it has a flow of income which it subsequently transpires is derived from conduct which is then determined to be unlawful, but it values its purchase on the basis of that flow of income, and so it pays a price which reflects the money that's coming in.
You don't dispute the economic success of the point?
We don't dispute that we're entitled to be fined on that basis. What we dispute is the suggestion that our fine should then be uplifted to reflect a financial benefit of which simply has not come to us. And there were a couple of answers suggested to that. It was said, first of all, well, it's not legally relevant. Well, if it is being relied on to uplift our benefit, then it is legally relevant in our submission. And then it was said, oh, well, we're entitled to take into account the benefit from the cartel phase. because you're being fined as the economic successor. But insofar as that money was still in the entity when Actavis purchased it, it would have paid a price that reflected it. Insofar as that money had been taken out before it was purchased, it didn't get the benefit anyway. So none of this actually justifies uplifting Actavis's fine by reference to the purported financial benefit of the infringement.
So you pay a price earnings ratio assuming that you get a fixed revenue stream. That turns out not to be correct because you end up disgorging it in fines.
Because it is subsequently determined to be unlawful. So we've paid for...
So you're down on the deal, as it were.
To suggest that it needs to be uplifted to reflect a financial benefit in the context of a successor is, in our submission, misconceived. Finally, and very briefly, on the statutory cap, it's not in dispute that the cap applies to each separate infringement. That's not disputed. It's not in dispute that the key question is whether or not you define one infringement or four. Professor Bailey referred you to some of the case law. Lest it be suggested that there is any sort of compulsion arising out of the case law for the CMA to take this approach, I would just turn up, please, paragraph 87 of our skeleton at page 100 in the bundle. I'm hoping... Yes, so what we have done here is cite 3 examples where a different approach was taken by the CMA. So in NAP, you've got exploitative pricing and exclusionary pricing in relation to different products, oral release morphine tablets and capsules across all strengths, and there was only, I think I'm right in saying, a single infringement. In relation to Flynn Pfizer, you've got the CMA found 4 separate infringements, one in respect of each affected strength of phenytoin. But then it recognised that all 4 of the infringements had taken place in the same relevant product and geographic market and issued a single fine. And then in paroxetine, you've got GSK, which is the originator. It sells a product that has different strengths and in different formulations. And it has different infringing pay-for-delay agreements. And the CMA did not find separate infringements in respect of each strength. We simply refer to those examples to suggest that there is no compulsion to apply the approach that the CMA has applied here that derives from the case law. We say, as a matter of fact, on the facts of this case, what it has done has resulted in an outcome which is excessive and disproportionate and which causes us to hit our cap coming up to 4 times, and we say that that is indefensible. My lords, unless I can assist further, I'll hand over to those behind me.
My lords, intent to negligence after May 2015. I'll try to be brief, of course. My main submission is going to be that my submission simply weren't answered. The CMA's metaphysical confusion about the undertaking continued, and we had some brand new confusion at the end about what was actually decided in H2, which I will try to address, but because it was new, it may be that that's something we need to come back on in writing. To locate these submissions concretely instead of metaphysically, I wonder if we could turn up the decision, core bundle, tab 23, page 693. This is the undertaking diagram, and it should hopefully clarify some of the points about economic successes that we have. So we have Auden, which includes at the top of the page Amit Patel and Meet Patel until 29th of May 2015. Auden we can see continues, but its business is transferred to Actavis UK. But from May 2015, the Patels have left, and as was helpfully confirmed in the exchange with Professor Bailey, that constituted a complete changing of the guard. There were no individuals who continued who could have held the relevant knowledge in their head. AM Pharma and Actavis UK are the alleged infringing entities, and then the parent company, Actavis Allergan plc, is the parent company represented by Mr. Johnston. And so my present argument is concerned with whether that allegedly infringing entity, AM Pharma, that becomes Actavis UK, possessed the relevant intention and negligence in respect to the unfair pricing abuses after May 2015, or put differently, whether the tribunal's finding to that effect is sustainable. If I'm right that you can't uphold that finding, it means that no penalty can be imposed in respect to the period after May 2015, but we do accept, because of the economic successor point, that a penalty can be imposed in respect to that earlier period. Of course, if the tribunal is with me on these points, we would then have lots to say about how the size of that penalty should be significantly reduced. So Professor Bailey characterised the point as being that intention walked out the door with Mr. Patel. He tried to say, well, that doesn't matter because AM Pharma remained as a company. But that continues to rely on this concept of the metaphysics of the undertaking, rather than asking the actual question, which is whether the undertaking at the material time possessed the intentional negligence necessary to cross the statutory threshold. So as to the meaning of that, I did that the state of mind concerned with the undertaking's awareness of the essential facts, or for negligence, whether it ought to have been aware of them. Professor Bailey took you to paragraph 111 of this court's judgment that was decided in relation to the previous appeal, and the comment that evidence of the subjective state of mind of parties to an anti-competitive agreement is not required. But that was the conclusion reached by the court in respect of infringement and what's needed for the finding of a common understanding continue. There's a distinct question that needs to be asked for intentional negligence, which is necessarily concerned with...
I think that was about what's meant by an agreement or concerted practice.
Yes, exactly.
I can't remember, there's a European Court judgment on, I can't remember what it is.
Exactly,
there is,
my lord.
I remember that, yeah.
Of course, you're not with us on that point, but the point is that the intention negligence threshold is a distinct test.
Yeah.
And in that very passage of the judgment, your lordship actually quoted paragraph 137 of Hydrocortisone 2 and explained why it wasn't inconsistent with the findings that were being made. So we then, in any event, I say we don't need to have this particular debate in relation to H2 because the point has been determined in my favour. The tribunal made a finding of absence of intentional negligence. And you had an attempt to reconstruct this right at the end. So Professor Bailey said it's not as if the Wilsons of the world were ignorant of what Auden had been doing. And he had a go at telling you that Auden that Octavis was aware of the essential facts of the 10 mg agreement. He said, oh, you knew about the transfer of value. But these are the very points that the tribunal has decided in Hydrocortisone 2. The tribunal made that finding expressly for the purposes of penalty. And you had a very belated attempt right at the end to persuade you to the contrary. So I think we do need to look at Hydrocortisone 2 again. This is Core Bible, tab 17, page 604. And at the start of the paragraph, the tribunal says... Page 604.
604.
Core Bundle.
Yep.
I'm grateful. So if we go... Paragraph 136 is concerned with the finding of infringement and the transfer of guilty knowledge of the tribunal called it for that purpose. Paragraph 137 starts clearly because it's relevant to penalty. It's important that we state that there's no intentional negligence on the part of later entities acquiring the holder of the MSD MA. Lord Justice Zacaroli yesterday focused on the point about acquirer, but we should note that subparagraph 1 is very clear that this finding is also made in respect of Actavis, so the successor undertaking that's said to continue the infringement. This is the comment at the end of subparagraph 1. It would be inappropriate to affirm a conclusion of negligent or intentional infringement on the part of successors to Auden on the basis of their individual subjective state of mind. Subparagraph 2 then talks about how there's also no reason to think that the subsequent entities should be aware of the remarkable features of these agreements. That's obviously the context to the tribunal's earlier comment, that there's no reason to think those entities were aware of the illegal aspects of the 10 mg agreement. In other words, the tribunal is saying these are the essential facts that rendered the 10 mg agreement unlawful, and the subsequent members of the undertaking simply weren't aware of those essential facts. That's why there's a finding of negligence. And then the very final section of the paragraph that Professor Bailey took to you does include the underlined word intentional, which introduces confusion. What I read the tribunal is saying there, if we can carry on to the following page on the screen. However, we do not consider these conclusions. At the end of this paragraph, the finding being made is if Auden was infringing, then so were they. And the reference to intention I take to be a reference to the fact that Actavis, as the economic successor, can be liable in respect of the earlier period and respect of Auden's conduct, which is what the tribunal is clear to focus on. And then 138 is clear in any event in saying what we're talking about is infringement. We don't think that for the purposes of infringement you need additional information. So that's in the time available right at the end. I can see your lords are reading, but I'm very worried about time. That's my canter through the very brand new submissions introduced at the end.
Is this just in relation to the penalty on the 10 mg agreement?
It is.
That's
and
all this is relating to?
This is precisely my yes.
But that's your submission, it's limited to that, is it?
This is the judgment in respect of the penalty of the 10 mg agreement.
Your submission on, is it only limited on penalty?
My submission here is that we thought that this was a clear finding, and the result of this finding is that the the finding of intentional negligence in respect of unfair pricing abuses is also unsafe.
I thought so.
Because of the submissions that I made yesterday. But in order
Yeah.
to be able to make that point to you, I also need the building block of this
Yes, quite.
judgment, which was attacked right at the end
Yes.
by the CMA. So the point there is that it's not right to say that the Wilson of this world knew all the essential facts. They didn't know about the 10 milligram agreement. What they knew was that Tarvis UK paid a lot of money to acquire an apparently profitable life-saving drug. They know that for some reason no generics are entering the market. The 10 milligram agreement continues until later in 2016. And we know that the ability to supply a product when others can't is capable of constituting economic value. That's something the tribunal did find. They know that the only other product in the market, Phenedrin, charges much more. They know that they have a full label NA, which at least some pharmacies place value on. And based on those facts that they do know, and the fact that they don't know about the 10 milligram agreement, I showed you yesterday the passages of the decision where the CMA placed weight on the existence of the 10 milligram agreement as supporting the unfairness of prices, and also the reason why prices climbed as high as they did, and why they took a longer time to reduce, is based on the fact that Actavis does know is it doesn't have the essential facts that render the pricing unfair, as found by the CMA. Investors, that's a submission. So if the final point to make is that if the court does retain doubts about what was decided in H2, the CMA has said, well, it's premature to consider these points. It's going to come back before the tribunal in January. That would be unsatisfactory in relation to H2 and surface elsewhere. What the tribunal has decided is clear, but it would be particularly unsatisfactory in relation to H1 because this is the opportunity for the court to grapple with that point, and for the reasons I've given, it's not a safe conclusion to find that there's intentional negligence in H1 either. My lords, I'm grateful. I'll turn over given the time.
My lords, I'm acutely conscious of the time. I definitely am in the graveyard slot now. 4 very, very short points in reply. First, I'm not going to deal at all with intention and negligence as a gateway point, but I do want to pick up on one thing Professor Bailey said, which was we didn't need to put intention to Mr. Stewart. And even if he's right as regards the gateway point, he's wrong as regards the uplift. So that's the crux of my first submission. In order to justify the uplift vis-a-vis Allergan, it was necessary to take that point and to put it by way of cross-examination, because, as we know, the uplift has to be justified vis-a-vis Allergan specifically, and Allergan's specific culpability for the purposes of the specific deterrence analysis. And now, I want to make one brief point under this first heading. There was a notable moment this morning when my Lord Justice Zacaroli asked Professor Bailey, what should Allergan have done? And the answer you were given was, well, they decided to carry on and see how much money they could make. That is not a submission that's open to the CMA, because the CMA has not put its case on that basis. And it's no good to make that suggestion now, orally in this court, and to reformulate its case as it was put at trial. I've encouraged you previously to go to Mr. Stewart's evidence and also to the note on his evidence. I was going to take you to some of that. I won't do that now. But the suggestion that the view in New Jersey, if I can put it that way, was we're just going to carry on and see how far we can go with this, is not open to the CMA, where they didn't challenge the evidence that nobody within Allergan knew or should have known.
I think the contention was they in fact carried on, not that they decided to carry on. I may put it that way, but what happened in fact was prices carried on rising.
Well, my lord, I understood the submission to be being put rather differently.
If it's put that narrow way, do you have the same objection?
I don't object to the fact, as a question of fact, that prices remained at that level and then they began to fall towards the end of the Allergan period and continued to fall into the Intas period.
That they deliberately done something.
To the extent the suggestion was being
deliberate decision, and your point is that there's no evidence.
Exactly. To the extent the object question is what should Allergan have done? If the answer is, as I've got it and I took it from the transcript, they decided to carry on. Professor Bailey may be about to...
If I could just confirm, Lord Justice Zacaroli has correctly understood that was the extent of my submission, as a matter of fact.
I'm very grateful. Well,
No allegation of intention.
No allegation of intention, and I won't repeat the point. Hugely significant when we come to stage 4 of the finding analysis. The next point under this heading, very briefly, was a suggestion that all that Allergan established was the state of awareness of one individual. Again, that wasn't put to him at trial. It could have been put to him at trial as a question of practicality, and you'll see from his evidence he was the only person, or certainly the best possibly placed person in New Jersey to have any insight, if there was any insight at all, into these matters. Second submission, very quickly. Professor Bailey offered no clear answer to the 2 authorities that I took you to yesterday. Firstly, Kia, in relation to the need for there to be a rational connection between turnover and infringement, and my submission that here there is none. Secondly, Deutsche Telekom, and the submission you saw in that judgment that where there's an uplift for a parent company, there must be something specific and culpable. And that's why it's important, as Professor Bailey says, that it didn't need to be put. I say it did need to be put, because that is a necessary part of an uplift of this kind. Third, there were lots of points made about what was described as the multifactorial assessment. We're agreed on the CMA's analysis there's an unlawful profit of £25 million. There was no answer to the point that we have a fine of £75 million. And it's not clear at all how that could provide a proper basis for it. Prices to the NHS were relied upon with respect. Prices are a function of profit, so that's the same point. There was also reliance on turnover, and really the submission in truth, if we boil it down, was big firm, big fine, but don't worry, this wasn't mechanical. But there was no explanation as to why it wasn't mechanical. We had the numbers. I didn't shy away from those at all yesterday in terms of the share of turnover and profit, but it's not enough to simply say this is a small share of turnover. There has to be more. You've seen that on the authorities. There's a need to see matters in the round. That leads me to my 4th and final point. I'm grateful for your indulgence. The submissions today notably lacked a willingness to take the famous step back and look at matters in the round. You heard the submission yesterday, £75 million for a 9-month period. You heard the submission that that wasn't justified. The only answer of any substance you were given was, well, it's a big company. But there's a problem at the core of that submission. The CMA didn't take a step back and didn't look at matters in the round. And in those circumstances, I do encourage you to set this penalty aside, my lords, or very substantially reduce it. But if you're not minded to do that, I encourage you to remit it, but also with some guidance in the light of what you've heard about the proportionality of this penalty, because I do say that it is obviously disproportionate and obviously not capable of justification. My lords, I'm acutely conscious of the time. I'm very grateful. I've trimmed my sails, and I'm thankful for the extra minutes. Unless I can assist any further, those are my submissions in reply.
My lords, I rise with great hesitation. There are just 2 points of correction to avoid any confusion. First, to clarify the CMA's position in the light of a submission of Ms. Ford cases, we maintain both of the first 2 sentences of paragraph 44 of our skeleton argument, but on the basis not of a linguistic difference between the parties. A price above cost plus may be justified by patient benefit in circumstances where that benefit would obtain under competitive conditions. Patient benefit alone is not enough. That is what the tribunal meant, we say, in paragraph 339. Second, Ms. Thomas suggested that Mr. Bailey's argument in relation to paragraph 137 of the tribunal's judgment was novel, developed for the first time orally today. That is incorrect. It is reflected in paragraph 98 of the CMA's main skeleton. I'm grateful.
Thank you. Can we then turn to the question that we asked everybody about yesterday in relation to identifying arguments? So we start from the proposition that the decision, we've seen what's in the decision, the judgment, we don't need to go back to it, we know what's in the decision. A lot of the argument today about penalties almost sounds like an appeal against the CMA's decision rather than the CAT judgment. And for that reason, we would like to know, almost just have a list of issues. And you said you would talk. I understand time is short, but we'd like some guidance on where you are.
Yes, so we have made a degree of progress in producing a table which identifies the issues and cross-references to where those issues were raised below in the submissions that are in the bundles, and then cross-references to whether they were addressed in the Tribunal's judgment at all, and to the extent that they were, where.
And have you sent that to the CMA?
We have not yet sent it to the
Well,
CMA.
so-
It's a work
I
in
think
progress.
it's
It's
a
a work.
draft has been
Okay,
passed to
I
us.
imagine that would be the answer.
Yeah.
We're not criticising you for not having done that. You will need a bit of time. We prefer that it was done properly and fairly and comprehensively rather than hurriedly.
Indeed.
Any ideas of timing? We're not going to produce an exemplary judgment this evening.
Astonished you, my lord. One paragraph.
For our part, we have inputted our elements into it, and so we think we're largely there. We have only recently provided it to the Intas team.
So,
7 days?
yes.
That would suit us.
We'll seek to provide it to CMA once we've put our own input in
and
early
then
next week.
effectively you'll produce to us an agreed
Yeah.
schedule. I'm conscious the only person we haven't heard from today is Miss John. Is there anything you wish to add by way of correction or something?
I'm grateful for the opportunity, but no thank you, my lord.
There you are. Much can we then thank the parties for the great help they provide us both in writing and orally? Can we thank also Opus for their assistance? The speed of reaction has been very impressive, and I think we've all benefited from not having to scurry around to grab the files. We will obviously, once we receive your responses, we will then decide whether we wish to hear anything more from you about them. We rather suspect we can work out from what you say whether they're material or whether they're serious points, but if we do need assistance, we will come back to the parties in due course. We will produce a draft judgment in the ordinary way in due course for editorial comment only. The normal confidentiality requirements apply, and we will hand it down when we are ready and when we had all of the comments. I don't think there's anything more to add. Thank you all very much indeed.
Court round,